Huh?
Withdrawal tomorrow.
Tomorrow, okay.
My lord, I beg to mention item number 28. The connected case has been listed tomorrow, my lord.
20.
20.
Ah.
My lord, connected case, my lord, WPC 4232 of 2022, my lord, has been listed tomorrow.
So,
Can it be taken up with the connected case?
no, there are other matters. Item 20,
Yes, my lord. Yeah, I'm sorry, 28,
28.
my lord.
This is by order. Who has mentioned it?
Yes, it was mentioned by me, my lord.
Then, what kind of a mention are you making? Connected matter tomorrow, listed tomorrow.
My lord, then my lord, let's take up.
Once you make a mention, we permit you, you are expected to do the matter.
Other cases fixed tomorrow, my lord.
Huh?
Other cases, my lord.
But you mentioned it.
Yes, yes, my lord.
Let the matter be called up. Let us
My
see.
lord,
My item number 11, my lord. The lordship is directed to produce some orders, my lord. Till date, my lord could not get the orders. That's why.
Directed the petitioner.
Petitioner to produce.
At the request of Mr. P.J. Soikia,
1 week,
matter
my
stands adjourned for 1 week. 1 week.
Obliged.
May it please your lordship. Lordship matter was filed yesterday. Kindly maybe taken up. It may be listed
Subject to clearance of defects, it will be listed on Friday.
on Friday, my lord.
No. Registry will list it on Friday. Don't worry. If you clear the defects, it will come. 48 hours
Urgent
maximum.
matter, my lord. Very urgent matter.
What is the urgency?
Urgency, my lord, it's a doctor and sonographer. By a direction by the interim order, he has been stopped for conducting sonography. So he's facing problem.
Sonography.
Yeah,
He's employed where?
He's not employed. Private. He's practicing private.
Who has issued a direction?
Appropriate authority.
You do one thing. You find out from the registry. If it is not going to be listed on Friday, you make a mention tomorrow.
Obliged.
Yes.
With your lordship. With your lordship, due permission, may I pray for listing of the matter in hearing column, lordship. Since 14.9, it has not been listed.
It will come in the part 2 list, madam.
No, 2022 matter, lordship.
It will come in the part 2 list. We will take it up from part 2 list. We can't direct you to list on a hearing column.
Part 1 list, there are some hearing matters listed tomorrow.
There are hearing matters because we have heard or we have fixed these matters, old matters. And from part 2, these matters are being picked up and put in the part 1 list.
Lordship, 2022.
You will list it for orders, let us see.
Lordship.
You let it come on next week sometime. Wednesday?
Lordship, for orders.
For orders, yes.
Obliged.
May it please your lordship. So fresh petition, your lordship, to be listed on Friday.
Same thing, if it is cleared by the registry, it will come on Friday. You find out if defects are cleared, etc.
My lord, for DL 33, may you be pleased to adjourn the matter for today and kindly list it after like 4 weeks?
For?
DL 33. We have informed the.
What is DL? What is DL?
Daily list. Item 33. Sorry.
33.
Yeah.
You are making a mention on whose behalf?
Jyotirmoy Roy.
Behalf of the petitioner.
Yeah.
All right. Matter be listed after 1 week. After 1 week. At the request of MS So-and-so, learned counsel appearing on behalf of the arguing counsel, Mr. J. Roy, senior counsel. Yes.
May it please, your lordship. My lord, item number 6, motion matter, my lord. It was directed upon the petitioner to file an additional affidavit, my lord. My lord, we have filed it today. My lord, can it be listed on Friday, my lord? Since it's a motion matter, my lord.
All right. Item 6 on Friday, along with the additional affidavit stated to have been filed by the petitioner.
Deeply. My lord, I pray for listing of a writ petition, my lord. It was last listed on 29/2023. Supposed to be listed after 2 weeks. Regarding notional promotion, my lord. Already rejected.
List it, give a date for admission.
Yes, any date.
For admission.
May it please, lordship, for withdrawal.
23rd. Not 23rd. Give it in the week after 29 or 30. 30.
May it please, lordship.
May I please your lordship and list the matter for admission, lordship. On Friday,
Admission, all right, on
Friday.
30 November. Yes.
Lordship, for withdrawal, lordship, Tuesday, lordship.
Tuesday, let it be tomorrow.
Tomorrow.
Yes, tomorrow.
One admission matter, in this matter, what happened, the petitioner is not getting salary from last 9 years.
You want the
Last
matter to be listed?
Yes, Lord. It's the urgent matter.
Urgent 30 November.
30.
30 November.
Okay, any date before that?
No, before that, not possible. 30 November, yes.
Petition for your lordship, praying for listing of a petition regarding regularization of service.
Admission,
Your lordship.
admission 30 or any other date.
Next lordship, lordship.
It will be on 30th November.
Obligation.
Item number 3.
Yes.
I'm on the pair for adjournment. My senior is on personal matter.
Item 3, you wait, let the matter be called up. It'll just come now. Wait till the matter is called up. Yes.
Lordship, I beg to mention item 2, the consent of other side has been taken.
You wait, we'll call up. Yes.
May I please, lordship? I beg to mention item number 7, lordship.
7. Yes.
Kindly adjourn for the day.
7 adjourned for the day. At the
I
request of learned counsel for so and so. Yes.
Me, please, your lordship. Your lordship, I beg to mention for the listing of a WPC matter, your lordship.
For admission, motion,
Order for orders.
for orders. All right.
On Friday, it will be taken up on Friday.
Not Friday. Let it be some next week sometime.
Next
Give a date, please. 17th
17th.
November. List on 17th. Yes.
May I please, your lordship? I beg to mention item number 35. 35 may kindly be considered at 2 p.m. or second half.
35 at 2 p.m.
Sir, 2
At 2 p.m.
at 2 p.m. Must.
May I please, Lordship? Lordship, I beg to mention item.
If you want to make a mention, you should come fast. You don't make a court wait because you are coming forward to make a mention. Yes, tell us.
Lordship, item number 10. Lordship, in this matter, the learned counsel, Mr. Yargo, is out of station, Lordship.
Item 10 adjourned for the day. Yes.
Lordship, obliged.
Yes. Please. At the request of Mr. R. Muzumdar. To pull it.
Yes.
Huh?
Item 55.
55.
Yes.
6299.
Yes, madam.
It is submitted by the learned counsel appearing on behalf of Mr. R. Muzumdar, matter stands that does not wish to press the writ petition any further. Accordingly, the same stands dismissed. As not pressed, interim order, if any, stands recalled.
Obliged.
Yes.
My lord, matter pertains to confession, my lord.
Yes.
Last occasion, it was directed to the to get the instruction.
Any instructions, Mr. Goswami?
Lordship, instruction yet to receive. Lordship.
What is your
Otherwise,
prayer? What is your prayer?
Otherwise, Lordship, this is the matter of 2011, Lordship. Now it is 2023, Lordship.
But my lord, the last communication on dated 2/8/2021, my lord. Annexer 8, lord.
His only case is that it has not been considered or
Yes, Lordship.
by the DLC.
Yes.
That instructions you could not get it.
Lordship, I
From-
will get, Lordship.
Huh?
I will get, Lordship.
Why we wait? We dispose it off with a direction.
Yes.
To consider, and if it has already been considered, the copy be served on him.
Lordship, Lordship.
Huh?
But regarding, Lordship, it may be. The court may.
Heard learned counsels for the parties. This writ petition is filed by the petitioner, praying for a direction to the respondent authorities to consider his claim, which is submitted, it is stated to have been submitted for appointment under the compassionate scheme. Stop. Petitioner's father was appointed on so and so date. He, while in service, he expired on so and so date. And thereafter, the petitioner, being his son, petitioner is the son.
Yes, ma'am.
He submitted his application for appointment on compassionate scheme as its father. It expired on 27/11/2011 while on service. Stop. Because of the death of the father, who was the sole earning member, the petitioner's family suffered grave financial distress and other misfortunes. Stop. Petitioner by that time had completed his higher secondary from so-and-so school. Stop. Although the application was submitted, but the same was rejected. It was rejected earlier.
No, ma'am.
What is have you stated in para 6? Was considered and rejected by the
Yes, madam. Vacancy is not.
huh? Minutes of the DLC dated 3/01/2014. It was considered and rejected.
Yes, Lordship, what is no,
But my lord, whether it was considered or rejected,
no,
I have just informed, they have not informed me.
no, but you categorically on affidavit stated that the matter was considered and rejected. Also, there is no force
It
in
is
this case,
submitted
Lordship.
that the DLC, while rejecting his claim, did not consider the vacancies available in the respective departments, and his claim for compassionate appointment was rejected without the department considering the vacancies available. Stop. Under such circumstances, he approached the authority and filed several applications. He made his application dated 11/8/2019 has remained pending, which has not been disposed of. The same said application was forwarded. He submitted the said application to the Executive Engineer, Rongia Division, Irrigation, which was forwarded to the Deputy Commissioner, Kamrup Rural.
Exactly.
Thereafter, another representation dated 2/8/2021 was filed before the Executive Engineer, Rongia Division, Irrigation, but no response has been received from the respective departments. Stop. Para. This court earlier permitted the respondents to obtain required instructions in the matter. Today, when the matter is called up, Mr. Goswami, learned government advocate, submits that instructions are still awaited. Considering the prayers made in the writ petition that his grievance is directed against the non-consideration of his applications filed before the authorities, and in view of the fact that no instructions are forthcoming from the respective departments, this court does not consider it necessary to keep the writ petition pending. Accordingly, this writ petition stands disposed of. Stop. The respondent authorities, more particularly the Deputy Commissioner, Kamrup Rural, who is the chairman of the district level committee, will consider the application stated to have been filed by the petitioner and forwarded by the executive engineer, Rongia Division, Irrigation, and pass necessary orders on the same. So, if any orders in the meantime have already been passed, then a copy of the same be furnished to the petitioner. Stop. The entire exercise be completed within a period of 60 days from the date of receipt of a certified copy of this order. Stop. Writ petition accordingly stands disposed of in terms of the above. No order is to post. Mr. Goswami appears for respondent number 4. MS appears for respondent number 1 and 3.
I'm on 2 and 4.
Yes, it will board councils.
Deeply obliged, my lord.
None appears passed over. Somebody made a mention.
Yes, Lordship, the consent of the petitioner has been taken to adjourn it for 2 weeks.
Mr. Borthakur, learned counsel appearing for the Forest Department, submits that the matter be adjourned, enabling him to get the necessary instructions. Accordingly, matter stands adjourned for 2 weeks. Mr. Goswami appears for the state respondents. Yes, you are praying for some time. Yes, at the request of MS so-and-so, matter stands adjourned for some time. Any instructions, Mr. Goswami?
Instruction, Lordship, it is awaited. Lordship, regarding instruction, no extra copies furnished to ask. Lordship.
You furnish extra copies list after 1 week.
Lordship.
Yes.
May I please, Your Lordship, in this writ petition, I have 2 prayers, Lordship. At this stage, I'm praying for MACP, the financial upgradation, Lordship. I'm covered by circular 20, page number 23, Lordship, of 2017, where it is provided that when there is no scope for promotion.
Who is for the PWD? PWD.
Lordship.
First time,
You are praying for promotion.
Yes.
Or in the alternative upgradation.
Yes, Lordship.
MSCP.
I think that since it is personal post, there is no scope for promotion, but Lordship, MSCP, I have my chance, Lordship, page number 23. Roman 3, Lordship. The scheme will also cover isolated posts where there is no scope for promotion at all. So at this stage, I'm praying for this benefit, Lordship. In 2005, I was regularized, Lordship. We are in 2023. 10 years already elapsed, Lordship. It is first financial upgradation, Lordship. I may be given.
Are you eligible for that?
Yes, Lordship. I was regularized in 2005, Lordship. And in the meantime, I passed higher secondary examination also, Lordship.
Science. Science.
You are what? Regularized as?
Regularized, Lordship.
As grade 4.
Lordship,
grade 4. 2005, grade 4, Lordship. So far as that promotion issue is concerned, Lordship, that issue has been settled by the division bench. But the second issue, whether they are entitled to MACP or not, Lordship, that issue also was considered by the learned division bench, Lordship. Instruction in those cases are pending, Lordship. Lordship, in this case also, I would like to pray for some time, Lordship. In the meantime, I will obtain the instruction.
There is some pending matter.
In the division bench, some pending matter.
Today also item number 27 before division bench 1, Lordship, writ appeal 203 of 2023. That is also regarding this from a personal post, and in that case also, honorable.
No, the issue is whether issue before the division bench is whether promotion is available or not, or is it a case of entitlement of MACP?
Lordship.
Which one?
No, Lordship. In the division bench, it is an appeal against order passed by the learned single judge, applying the order passed by the learned division bench that persons regular.
Personnel post not available.
They are not eligible for promotion, Lordship.
But I'm praying MSCP only at this stage, Lordship.
Lordship, that was also a question posed by the learned Chief Justice, Lord. So let this instruction come, Lord.
All right. Heard counsels for the parties. The learned counsel for the PWD submits that the question of whether the petitioner would be entitled for MSCP benefits as prayed for would require instructions, for which he prays for some time. Stop it is further submitted that the issue is also pending before a division bench of this court. Accordingly, matter stands adjourned. Be listed after 2 weeks.
Lordship will grant some more time.
Some more time.
The person is working on.
Yes.
If he is entitled,
It's only a question of whether applicable or not.
that issue will require some examination.
Today also may say.
After 4 weeks, Lord, something concrete I will get in the meantime.
But technically, you may not be entitled.
Lord.
Because if you're not eligible for promotion, this is in view of, this is to take stock of certain situations where there is no post to promote.
Lordship, when there is no.
Anyway, this is a subject to such instructions coming. Matter be listed after 3 weeks.
Okay. The date may be fixed, Lordship.
List on 15 December.
Repeat.
15 December.
My pleasure, Lordship. Lordship, application on the ground of compassionate ground.
Compassionate.
Yes, Your Honor. Lordship, my father was a Halase in the PhD department and died when he was on duty.
Your case has been rejected
Rejected, Lordship.
by the DLC.
DLC.
Where is the rejection order?
20, page number 20.
Your
My case is in 23.
23.
16, para number 16.
Serial number?
16.
16.
16.
Your name?
Nayanjoti Das.
Nayanjoti Das.
There is no ground, only they mentioned that within 1 year we have not applied. Therefore, it is rejected.
You did not apply within 1 year.
My brother actually applied within 1 year, but no communication was passed to him, whether his application was
But
rejected.
that will not give you the benefit. Where is your brother?
Brother, now we're actually waiting whether he get or not. But when DLC, the department did not communicate.
Yes.
Yes. When the official did not communicate my brother, then I applied for the post because I was eligible actually.
No, but this will be dependent on the who makes the application.
First, within 1 year, my brother applied.
So your brother is not before the court. What happened to him? Where did he go?
He gone to other state for some working purpose, and he made an affidavit that he has no objection if I get the job.
That is not sufficient. You did not apply. Your brother's application cannot be converted to your application.
But he applied first, but no communication was made to him.
But he is not before the court. You are not filing the writ petition in representative capacity. You are filing on your own behalf. So
So if it is possible to give some time.
what more infirmities can you point out in the order?
If it is possible to give some time to represent my brother.
Yes. Who will represent?
My brother.
He wants to file a separate writ petition.
No. That he will mention that he has no objection if I get the job.
No,
If
your
application is-
getting the job doesn't help. So it is based on the application. Who made the application?
Now I made the application.
No, you
When
made it
I-
after 1 year, so therefore it has been rejected. That is what the guidelines say. Your brother's application cannot be treated as your application. You get instructions, Mr. Bothakur, to find out what happened to his brother's application.
Yes.
What is the status of his brother's application? Can you get it
Yes,
by
I'll-
next week?
I'll get it.
Next week?
Yes.
Third learned counsel for the parties, Mr. Bothakur, learned standing counsel, Forest Department. Is it forest or what?
PHC.
Hmm?
PHC.
PHE department. We'll obtain instructions as to the status of the application stated to have been filed by the brother of the petitioner seeking compassionate appointment.
Lordship, something came to our notice. At serial 1, there is another application, Noyan Jyoti Das, could not be finalized due to incomplete proposal.
You get your instructions on this. You get your instructions. You find out from the Commissioner of Police, Mr. Sarma Borwa. Who is this Noyan Das, Noyan Jyoti Das? Is he the same person or different person? Matter be listed again on Wednesday, on which date the respective councils will obtain required instructions. It is pointed out by the learned government councils that in the minutes of the meeting held on 26/09/2022, there is a serial number. At serial number 1, the proposal of one Sri Noyan Jyoti Das was referred, which could not be stated to have been completed due to, which could not be finalized due to incomplete proposal. Again, at serial number 16, there is a reference to another Sri Noyan Jyoti Das, whose case could not be considered by the or appointment under the executive engineer PHE Guwahati, as the said application was not filed within a period of 1 year. These instructions will be placed before the court on the next date fixed. Give him extra copies. Extra copy or no copy? Do you have a copy? You have not been given a copy. Give him a copy now.
Given.
They must have served the copy in your office.
I'm not saying that he has not that one copy for which he tried to file. I need to extra copy because I have to send it to a department.
You just call for send this instructions and find out what they can tell you from the record whether both the persons are one and the same person. That is the only instructions you require. I know if he'll serve. If he doesn't serve, then what happens? We are not issuing notice. We are only asking you to get the instructions. You can give the references to your respective departments and find out whether these two persons are one and the same. That will be available in the DC's office. List on 17th November.
Lordship, can you take the matter after a couple of minutes? My senior is on his way. From what number?
Your senior is just behind you.
Yes.
Yes.
Amana, this matter relates to claim for retrospective effect of his promotion matter. What happened? The petitioner He is a junior engineer, and he has obtained the AMIC certificate in civil engineering. And my lord, there was some queries whether that is valid for the purpose of treating it as a BE degree, and that has been settled by this honorable court. So, my lord, he was also in a petition in an earlier writ petition. The court directed consideration. In the meantime, my lord, by virtue of his seniority, he has been promoted. But the persons who are similarly situated in same degrees, same certificate from AIME, they have been promoted earlier. So his prayer is to consider his, my lord, promotion from a retrospective effect. And to that effect, my lord, there is a representation. My prayer would be, my lord, your lordship time direct that his representation will be considered. With that, my lord, your lordship may dispose the picture.
Where is the representation?
Representation, your lordship will find that, my lord, the page, the detailed representation. Page 80. Page 96. That is a representation to the commissioner, giving all the particulars. In fact, my lord, other persons who were also similarly situated like him was not considered from promotion earlier. They have also been given, my lord, in the meantime, by virtue of an order of consideration from this honorable court.
Yes, what do you say?
No issue, your lordship disposes of this matter, directing the authority to dispose of the representation. But only one thing I would like to point out, lordship. Here it is not on acquiring a higher degree, lordship. It is not promotion to the higher grade.
We don't know. His only prayer is to for the authority to dispose it of.
In fact, the prayer promotion word is not appropriate. Lordship. That is
Whatever it may be.
Lordship will dispose of.
Whatever it may be. Heard learned counsel Mr. M.K. Chaudhary, senior counsel for petition resisted by Mr. M. Shakar. Mr. P. Nayak for PWD department. The petition is before this court.
Lordship, I am appearing for 2, 3, and 4.
2, 3, and 4.
Direction has to be given to the respondent number 2, my commissioner.
Yeah.
2, 3, and 4. 2, 3, and 4. Mr. Sharma Borwa appears for respondent 1. The petitioner is aggrieved by the non-consideration of his claims for seniority with effect from 16/9/2015, when the department had given promotion to similarly situated persons like the petitioner. So, without going into the specific facts, the limited prayer of the petitioner is at this stage is that the representation dated
25/8/2023
before the Commissioner and Special Secretary Government of Assam PWD Department had seeking for prayers, making prayers for consideration of his claim for seniority with effect from the date when the other similarly situated persons were promoted has remained pending and not been disposed of. He submits that at this stage, a direction be issued to the concerned respondent, namely the respondent number 2, to consider and dispose of his representation by way of a speaking order. If required, the petitioner can also be heard, and relevant documents and materials, if required, may also be called for by the respondent number 2. The entire the respondent number 2 will carry out these orders within a period of 30 days from the date of receipt of a certified copy of this order. Writ petition accordingly stands disposed of in terms of the above. No order is to cost. Yes. Some affidavit you filed, additional affidavit.
Yes, I have filed at the
So his case is that these people who had applied for had gone and joined somewhere else. Now these posts are lying vacant. He is a person eligible. He requests consideration. That's all.
Let me have the instruction, madam. Specific, that is everything.
In the meantime,
they can be accommodated.
as and when required, I may be engaged, Lord. Because abroad is an essential service, health service, scavenging.
So within 10 days, I will have the inspection.
All right, all right, all right.
Whether in the vacant post, which are lying vacant, whether they can be accommodated.
That can be, that is
Because they have participated.
that is sufficient, Lord. If my parent renders this help.
When do we fix it?
10 days, exactly 10 days.
20.
Lord.
20?
Yes, 20th.
The grievance of the petitioner is that pursuant to an advertisement number 17 dated 7/12/2021, recruitment for 145 vacant posts of sweeper/cleaner were advertised. Stop. Advertised by the Director of Health Service, Assam. Stop. Again on 10/12/2021, Director of Medical Education, Assam, advertised, issued a similar advertisement for recruitment of 104 sweepers, including for recruitment of different categories of grade 4 personnel, including 104 sweepers through online application. Stop. The petitioners who are occupational cleaners offered their candidature. For the joint recruitment process. Stop. Persons thereafter were selected for the post of sweepers. However, those selected persons joined in other posts as grade 4 instead of the posts for sweepers as advertised. Stop. It is the submission of the learned counsel for the petitioner that all these posts for sweepers are lying vacant as on date. It is his submission that since the petitioners are eligible candidates, they should be accommodated and permitted to work and in these vacant posts, as the services which they render are indispensable and necessary for both the departments. Stop. Para Mr. B. Gugoi, Learned Standing Counsel Health, submits that he would like to obtain specific instructions on this and request for further time. Accordingly, as agreed to, let the matter be listed on 20/11/2023, on which date instructions as sought for will be placed before the court by the Learned Standing Counsel Health. Next, a copy of the writ petition
That may be served today.
be furnished to the petitioner
Tomorrow.
by tomorrow.
Have to get it.
By tomorrow. Send him a soft copy if you want. Yes.
May it please the Lord. This is the matter wherein an temporary hand has been sought to be replaced by another temporary hand. The petitioner on the last occasion, this honorable court was pleased to direct the respondents to get the instructions. They have initiated recruitment process, my lord, for filling up the post of lecturer physiotherapist consultant. And
Who's for the respondents?
my lord, Union of India, my lord.
Union of India.
Mr. H. Gupta appeared on the last occasion, my lord.
Who's for the Union of India? Any counsel? Okay, heard Mr. H.K. Das, learned counsel appearing for the petitioner. The petitioner was appointed as a lecturer physiotherapist.
No, he was appointed as physiotherapist,
Physiotherapist.
and he's doing the work of lecturer physiotherapist because there was no person holding that post, my lord. For all practical purposes, since 2006 till date, my lord,
He is appointed as a physiotherapist in the Composite Regional Center for Skill Development, Former Rehabilitation and Empowerment of Persons with Disabilities, Guwahati, established at the Guwahati Medical College Hospital. Stop. Although he was appointed as a physiotherapist, he is performing the works of a lecturer, physiotherapist,
consultant within bracket, my lord.
consultant, and he has been rendering his services on temporary basis since 2006 till
Yes.
date. Stop. Thereafter, the government has been issuing extensions. Stop. The respondents thereafter issued an advertisement dated 22/7/2022.
22/4/2023, my lord.
22/4/2023
361.
for filling up the post of a lecturer.
Lecturer physiotherapy
Lecturer, physiotherapist, within bracket consultant.
consultant.
However, what has happened to the selection process?
My
Not
lord,
completed.
that's what the instructions were sought for, my lord.
However, the respondents are attempting to replace the petitioner by another ad hoc person. Stop this. Learned counsel for the petitioner submits that this is totally opposed to the provisions of law, as an ad hoc person cannot be replaced by another ad hoc.
Yeah.
Without there being specific reasons
Yeah.
cited by the department. Stop. On the last occasion, the respondent counsel was directed to obtain instructions as to the status of the recruitment process initiated by advertisement dated 22/4/2023. Stop. Mr. Sarma Borwa, learned counsel, submits that he has no instructions as the matter was represented earlier by Mr. H. Gupta. Stop. Accordingly, we grant further time to the learned CGC appearing for the respondents to obtain the necessary instructions and place it in the court, before the court. Matter be listed again on 1st of December. Interim order dated 19/10/2023 will continue till the next date fixed.
Only one prayer I am having, my lord. As of date, I don't have any instructions what they have done with the selection process. If they fill up this post of lecturer physiotherapy consultant, my lord, then I'll be nowhere. Lordships has protected me, yes, true.
They shall not be.
This protection is with regard to, my lord, physiotherapist. So that they will not fill up the post.
Yes, what is the instruction?
My lord, on the last occasion, only notice was issued. So, my lord, the interim order was only to be considered after receipt of the instructions.
What are your instructions?
But I have not received the instructions.
Then-
as of date, my lord.
That is what we passed. You get it by 1st of December.
My lord. Lord, let the status quo be continued. Status quo is already given.
Whatever interim order was there, we're extending it. That's all. That's all. 1st of December.
If they fill up the post, then the post of lecturer physiotherapy. So that's why I was saying.
The interim
They will not
order,
fill up only that much, my lord.
the order was status quo with regard to the service they
Yes,
maintained.
Yes. Or
Now-
let them get the instruction, my lord, then I'll press my interim prayer, my lord.
That's right.
Not to fill up. Yeah, that will be proper, my lord.
Uh,
Let them get the instructions, my lord. What is the outcome of the selection?
Interim order is status quo with regard to the service.
True.
Service where?
In the institute, yes,
What?
as physiotherapy.
Doesn't say.
Doesn't say, yes, true. Highly obliged. Highly obliged.
May I please, madam?
Yes.
The petitioner is serving in the Assam Rifles as a warrant officer clerk. The lordship would have page 28, page 20, I'm sorry, madam, page 20. On the
20.
20.
20.
20, madam.
Yes.
On the 8th of May, my lord, an invalidation board was convened to evaluate him whether he should be invalidated out from service. A board of officers will assemble at a place and date fixed by the presiding officer to carry out the invalidation board in respect of so-and-so who was placed in LMC and invalidated out of service as a case of alcohol dependence syndrome relapse. Well, I had, coming to know this, I had applied for voluntary retirement, seeking voluntary retirement because my medical invalidation board would lead to a lesser pension. So I applied for voluntary retirement because I did not want to serve further. At page 21, lordship will find my voluntary retirement has been accepted. Point number 1, at page 21, voluntary retirement in respect of the following persons of our unit formation is hereby approved with effect from the date shown against it. Just above that, lordship will find that those numbers are written 1, 2, 3, 5, 7. Lordship will find headquarter IGAR North. That is my headquarters. That is where I serve. My name is at serial number AK, the last person on the list. Tilak Talukdar, headquarter IGAR North. It is 1st of February 2024, forenoon I go out. This has been accepted and lordship will find at the next page, page 22, the last serial number, copy 2. Pension applications along with advance pension documents are enclosed. For balance documents, lies with concerned unit. Lordship will find at page 22, the last serial number, 3. So my pension papers have also been processed. And I am to go out of service from 1st of February 2024. Keeping this in view at page 23.
Where is your name? Serial number?
Last serial number AK, my lord. The highlighted part, my lord, somehow photocopy it was highlighted. 1st of February 2024, lordship find. Voluntary retirement in respect of the following persons is hereby approved with effect from the dates shown against each. AK, warrant officer clerk, Tilak Talukdar, headquarter IGAR, North. 1st of February 2024. That is when I go out. Page 23, lordship will find the commandant medical officer. He says to the headquarters IGA North, serial number 2. Number so and so Tilak Talukdar is due for IMB. You are requested to send the individual for invalidation medical board to this unit hospital or take up a case with headquarter DGAR for info for cancellation of the IMB.
What is the meaning of this?
My lord, so now since I have been granted the voluntary retirement from 1st of February, the medical officer asks the headquarter, my headquarters, to take up a case with headquarter Directorate General, the top office, for cancellation of the invalidation medical board. Because lordship will find it was September then, I had around 4 months of service left. So they say we need not do the IMB. Fine. Getting no reply at page 24, they asked me to report on 3rd of October for the IMB.
Okay.
Then, my lord, immediately thereafter, at page 27, sorry, page 26, I am directed to approach the headquarter DGAR. Since the IG North is not taking any action, the medical officer asks me at page 26 to approach the headquarter DGAR. I approach the headquarter DGAR by page 27.
Now, what is the
Now, my lord,
you appeared before the medical board?
No, I did not, because now I was on leave. I am on leave till
What is the
yesterday.
procedure for grant of voluntary retirement?
My lord, that has already been done. Lordship will find at page 21.
No, that has been granted.
Yes, madam.
But why is it required to be placed before medical board as a
No,
matter of
because they had already
course?
started. They had already started. Lordship will find at page 20. Prior to the grant of the voluntary retirement, they had constituted the board. At page 20. Thereafter, my voluntary retirement has been accepted. Now, my grievance is, if lordship will kindly have my application at page 27, what happens, my lord? Why? I am agreed. Page 27, para 5.
No, so now when are you required to report?
Today I'm supposed to report back to the office. Immediately I'll be sent to the invalidation medical board. Today my prayer is, my lord, my application at page 27 not having been disposed of. They have not taken into consideration my acceptance of my voluntary retirement, and they are forcing me to undergo the IMB. Now, at this stage, let me not undergo the IMB. I can peacefully retire on the 1st of February 2024. Reason being, at page 27, my lord, para number 5, my pension would become less than 1/3 if I'm now to face the invalidation medical board. This application to the Director General has not been forwarded by the Inspector General now. Had it been forwarded, my lord, the IMB would be cancelled.
When is this required to be given effect to? This order at page 21?
Page 21. Yes, my lord. That lordship will find at down below, 1st of February 2024, I'll be struck off service. That lordship will find at the serial number 2. Please publicate the case of struck off service date. Struck off service date would be 1st of February 2024. And now being November, I have only got December and January to serve. If the invalidation medical board is given any effect,
then what happens? This gets cancelled.
Then I'll be invalidated of this, and lordship will find this was allowed by, at the top, lordship will see at page 21, it was allowed by the Director General. And at page 20, the invalidation board is by the DIG, Medical Superintendent. So junior officers convening a medical board.
Yes, Mr. who's appearing for respondent, yes.
Actually, for lordship, this matter perhaps has not been allotted to anybody, lordship. I am appearing for the first time today. Question
motion.
Okay, heard learned counsel for the petitioner. This writ petition is filed by the petitioner, aggrieved by the non-consideration of his representation. Where is your representation?
Page 27.
Dated?
That is
no date.
7th of October 2023, my lord.
Where is the date?
My lord, I have given it in the list of dates, but here the type copy did not come out.
Where is the original?
My lord, this is the type copy. I'll produce the original, my lord, by an edition.
Stated to have been filed before the
7th of
before the authorities, namely the Director Medical. So and so, please check from page 27. Stop. The petitioner is aggrieved by the fact that he was granted approval for voluntary retirement with effect from 1st of February 2024 forenoon, in terms of the order dated 12th of January 2023, issued by the Deputy Commandant. Stop. Learned counsel for the petitioner submits that prior to the grant or issuance of the approval for voluntary retirement, the respondents had convened an IMB, that is Invalidation Medical Board, within bracket IMB, to invalidate out of service such personnel who are considered to be not suitable for the services. Stop. The petitioner's case was placed or referred to the said IMB on the ground of alcohol dependence syndrome and relapse. Parallel counsel for the petitioner submits that notwithstanding the referral of the petitioner to IMB, the application for voluntary retirement has been approved with effect from 1st of February 2024. Stop. It is the learned counsel for the petitioner submits that In view of the approval, he has submitted his representations before the appropriate authority, praying for cancellation or recall of the order for putting the petitioner to attend the IMB. Stop. However, this has not been given effect to. Stop. Instead, the petitioner has been directed to go and appear before the IMB. Stop. It is the apprehension of the petitioner that in the event there is an adverse report given by the medical board invalidating the petitioner from service, from performing service under the respondent authorities, it will seriously prejudice his application, which has been approved for voluntary retirement. Stop. It will affect his pensionary benefits also. Stop. It is further submitted that the voluntary retirement has not been granted only against the petitioner. There are as many as there are several persons who have been, whose applications have been approved by
The directorate.
By whom?
By the
By the
directorate, page
Directorate
21.
General, Assam Rifles.
No.
Stop. The medical board was convened prior to the approval, and therefore, in view of the approval of the voluntary retirement, the medical board should not be, the petitioner should not be made to undergo the test prescribed for the medical board. Stop. Under such circumstances, he has approached this court praying for appropriate orders for staying any directions issued to the petitioner to undergo the medical board. Stop. Para Mr. Sharma Borwa, learned counsel, appears for the respondents. He submits that since he has appeared, since this is the first date, he would like to obtain specific instructions in the matter. He submits that the petitioner may undergo the medical test, which is a part of the procedure prescribed, and there is no infirmity in the order directing the petitioner to undergo the medical test. Having heard learned counsel for the party, it is this court is of the view that the respondents be directed to obtain instructions as to why the petitioner is subjected to undergo medical test under IMB, notwithstanding that his application for voluntary retirement has been approved to be made effective from 1st of February 2024. Stop. The respondents will furnish the necessary instructions before this court by the next date fixed. Considering the submissions made till the next date fixed, the petitioner shall not be subjected to the IMB. Stop. This interim order is subject to such extensions, which subject to such orders as may be made upon the furnishing of the instructions as permitted to be placed before the court by the CGC. It's taken on 1st December. 1st December. Extra copies of the writ petition be furnished within 2 working days.
Lordship, item number 57, I'm appearing for a repetition now. I'm surprised to see an IA, no copy is served on us. No copy of IA is served on
Who's
us.
for the applicant?
G.I. Borboya's name is shown in the cause list.
He is not here.
It's not here, Your Lordship, but no copy has been furnished to us.
Let him appear first.
On some other day.
We'll call up the matter again at 2. Let us see. Is an IA being filed? We'll call it up. Let us see.
Okay.
Let the order be passed in his presence also.
He was a peon in the establishment of the central authority matter. In the year 2006 matter, the authority has issued an advertisement for filling up the post of the peon matter. In the meantime, the several candidates were applied. The present petitioner is took part.
Lord, there is already an interim order in.
I may be allowed to explain the fact. The Noemoni was took part in the interview. Oh, sorry, and Noemoni was took second matter. But in the meantime, one post of driver matter. On it, he was dismissed by the authority.
Have you filed your response?
Milord, that's what I'm trying to say, Milord. I have already prepared the affidavit and sent it
Let
for
him file
vetting,
his
Milord.
response.
In the same order, one of Noemoni was dismissed and his ordered to be recovery of the same matter. But Noemoni petition was allowed matter. The High Court has not filed the objection matter. Noemoni petition was allowed and he was registered matter. Now his case is recovery.
Here he wants to file a reply.
They will file it, let me short that matter.
Mr.
2 weeks
H.K.
time,
Das,
I'll come up. Already.
Learned Counsel for the
Other case, they have not filed the affidavit matter. The person who was
for the appearing for the High
petition was
Court.
allowed.
Respondent number, Milord, just.
Raise 4 and is granted
3 and 4.
3 weeks further time to file
That
the
may be
reply.
different.
Appearing for 3 and 4.
3 and 4, Milord.
3,
Milord,
4 and 5. No.
In fact, Milord, respondent number 4 has been made by name party that has been struck down and only presiding officer was kept by this honorable court in the first order.
3 and 4, 3, 4 and 5.
No, 5 is the registrar, Milord. I am not appearing for 5.
3, 4. 3 and 4.
Milord.
Registrar has issued the order. It is not permission.
1 and 2, who's appearing?
Government of Congress.
Labor and Judicial. 1 and 2, Mr. Sarma Borwa. What about steps on respondent number? Service awaited. Oh, you have not taken fresh steps. Respondent 4 and 5.
We have taken later we have taken step, but notice is issued.
Okay. Service on respondent 5 has also been completed.
Notice issued upon the
Therefore, matter be listed after 3 weeks,
Right.
enabling the respondents to file their affidavit.
filing affidavit, madam. We have taken step, notice is issued upon both.
Yes, yes.
2
We have
weeks
taken note of.
3 weeks.
Mr. K. Sharma for the petitioner.
Deeply okay.
Hey, please, your lordship. My lord, in this case, record was called for my lord. Petitioner was discharged from service. Showing
Yes, records.
Lordship, my senior could not be present today, Lordship. So the matter may be put up next week, any day next week. Matter may be adjourned for the day, Lordship. My senior is
For
out.
the day. At the request of MS so-and-so, matter stands adjourned for the day. Be listed next week.
Kindly give me
MS S. Bora appears for the petitioner. It's on 17th,
time.
by which date the respondents will produce the records as directed earlier.
May I please your lordship? Lordship, as per this honorable court's order, we filed an additional affidavit yesterday. It has not come on record today. Lordship, my senior Mr. S.K. is also out of state. If your lordship permits, matter may be taken on 16th of
My lord, maybe for taking the affidavit, my
I have not heard, please.
My lord, this affidavit to be checked, my lord, the matter may be.
Yes, yes, it is submitted by the respondents that an additional affidavit has been filed. However, the same is not available. When did you file it?
yesterday, Lord.
is not available on record.
On 22nd, my lord, possible, my lord, because the matter has
It is submitted that the same was filed yesterday, the IE 711. Stop. Registry to verify and connect the said affidavit, additional affidavit stated to have been filed by the respondents. Mr. Kadir appears for the petitioner. List. Next week.
on 22nd, my lord, because SK might have some difficulties, he, my lord.
Or then let it come up in the month of December. December. List in the month of December. Yes.
Lordship, I'm praying on behalf of Mr. Y.S. Mannan. He has some personal difficulties. So, Lordship, may kindly pass over the matter for the day.
He has personal difficulties coming back. No. List after 2 weeks. At the request of learned counsel appearing for the petitioner. Mr. Goswami, additional lady, appears for the respondent state. Be after 2 weeks.
Lord, in this case, both the parties, in fact, were directed to file the affidavit to bring on record the subsequent development, my lord. I pray for some more time in this case, my lord. We would be receiving instruction by tomorrow, my lord.
It is submitted by Mr. S.K. Chakraborty, learned counsel appearing for the FCI, that instructions with regard to the matter be received within a day or two. Submits that he'd like to file necessary affidavit. Praise for
3 weeks time.
3 weeks time. Mr. A. Das Gupta, learned counsel, senior counsel appearing for the petitioner, does not object. The prayer made. List after 3 weeks.
If possible, date me kindly. Any date.
1st of December.
Date be applied.
No, let it be on, 4th of December. 4th of December.
May it please your lordship. My lord, in item number 24, my lord, 2 weeks time may be required for filing affidavit, my lord. Item number 23, we have filed affidavit.
Yes.
My leading counsel, lordship, is in another court.
Who is the leading counsel?
M. Kolita.
He is not there, then what can be done? They want some time to file affidavit.
Item number 2nd to 20, 24 to file for 23 to file for. So 2 weeks time.
Who's appearing in 24?
Both same.
Same counsels.
Yes.
Same counsels in both matters.
Yes, sir.
It is submitted by the respondent counsel, Mr.
SP Gwala, my lord.
SP Gwala. That affidavit is to be filed in WPC 2813.
My lord. My lord.
Item 23. Where do you want to file it?
My lord, we have filed affidavit, my lord, there, my lord.
Where?
In item number, my lord, 23, my lord.
You have filed.
File, my lord.
You want to file a affidavit in?
24, my lord.
24 in WPC 3603 of 2023. Stop. It is submitted that affidavit has already been filed on in WPC 2813 of 2021. Stop. He submits that similar affidavit be permitted to be filed in the other writ petition, which is WPC 3603 of 2023. He praised time for filing affidavit. In second item.
Otherwise, this matter is ready for hearing. This matter needs to be admitted and heard. In the meantime, they may file it.
All right, then.
Lordship may admit this petition, my lord, and it's the
Yes.
date of hearing.
Yes, my lord. We have
But
filed.
admission, the pleadings will have to be completed.
So first one is concerned, it is completed.
But both are connected matters.
That second one, of course, my lord, I don't know, my lord.
He says he has not filed an affidavit. He wants to file an affidavit. You file it within 2 weeks. Let it come after 2 weeks. Be listed after 2 weeks, enabling the respondent counsel to file the necessary affidavit. Mr. P.J. Soikia, assisted by Mr. Kolita and Mr.
M. Kolita.
M. Kolita appears for the petition. List after 2 weeks.
Obliged.
Yes.
The last occasion, therefore, the time for the inspection.
Lordship, as per my instruction, Board of Officers has been constituted to examine the eligibility of the candidates for old pension scheme, Lordship. It is in progress, Lordship. No, finalized. It is not finalized till date.
What is your prayer here? When is it likely to be any order to be passed by the board?
Lordship, it will take some time because all the paramilitary forces personnel has been examined who were appointed after 2004.
What is your submission?
My lord, let them decide.
No, they say they will require some time. That time has not been specified. How much time do you require?
Lordship, till date, we have no instruction how much time it will take, Lordship.
We can close this petition, giving you liberty to come back again.
Yes, if they are agreed. Lordship.
But do you have any document to show that the board has been constituted?
Yes, Lordship.
You furnish a copy.
Sure.
Heard learned counsels for the parties. This writ petition is filed by the petitioners who were appointed and were serving on the various units under the Assam Rifles. Stop. They retired from service.
No, they are serving, my lord.
They're still serving.
Yes, my lord.
Okay. It is the case of the petitioner that they're entitled to old age pension under the Central Civil Services Pension Rules 1972. Stop. Learned counsel for the petitioner submits that in a matter decided by the Delhi High Court in WPC 1819 of 2019 within bracket Mukesh Kumar directed the respondents to consider them to be members of old pension scheme. Sorry, this is not old age, it is old pension scheme in terms of the CCS pension rules 1972. Stop. The grievance of the petitioners are that they were appointed at a time when the old pension scheme was in place, and therefore they are not covered under the new pension scheme. Stop. Where pursuant to the court issuing notice, it is submitted by the Learned Standing Council CGC, by the Learned CGC, that the Assam Rifles Directorate has started the process of checking the eligibility of the personnel of the force who meet the criteria stipulated in the Department of Pension and Public Welfare Office Memorandum number so-and-so, dated 3rd of March 2023. Stop. For this purpose, a board has been constituted, comprising of a presiding officer and 3 members. Stop. The board has already initiated the process of examination.
Yeah.
They've started
Yes, Lordship.
this process. It is submitted will take some time as huge numbers of records are required to be examined. Stop. Having heard learned counsels for the parties, this court is of the view that since the respondent department has already initiated the process for examination of the claims of the petitioners by constituting a board as per office order dated 27th April 2023, this writ petition can be disposed of with a direction that the respondent authorities will continue with the process for examination of the claims of the petitioners by the board as constituted, and thereafter decide on the inter se claims of all the writ petitioners. Stop. Any such orders which are passed by the board or recommendations made by the board and consequential orders passed by the department will be served on each of these petitioners. Stop. In the event, needless to say, in the event, if the petitioners are still aggrieved by any such decision taken by the board or consequential orders passed, they are at liberty to approach this court. Writ petition accordingly stands disposed of in terms of the above. Interim order, if any, stands vacated. Copy of the instructions furnished to court is kept in the part of the case record. Yes. Yes, Mr. Sharma.
26.
Newer community, yes.
Yeah, Lordship, from our affidavit, it is clear, page 82. Yes, Lordship. Page 81, Lordship. The newer community is recognized as other backward classes by the state government. State government of Assam notified notification to enforcement. Newer community is recognized as other backward classes by the state government of Assam by notification dated 12 September 1961. Lordship. Government of Assam. No, but it is mentioned that in paragraph 6, Lordship.
So I think the CGC was supposed to inform.
Yes, Lordship.
No, last time twice the Lordship heard the matter, and it was admitted by the CGC. My lord, yes.
They'll have to give the instructions as to how they handle the status of the other candidates, which Mr. Sharma claims have been considered.
Yes, that is admitted. They have admitted it.
Then
So similar treatment.
you are representing the
State government.
State government.
Yes,
No, we wanted instructions from the
From
union.
the central government.
My lord, Constable is coming, my lord. Can it be taken at 2, my lord?
Huh?
Can it be taken at 2?
2 p.m. Okay. 2 p.m. 2 p.m.
My lord.
Here in this case, Lordship, in the last occasion, Lordship, the record is sought for, Lordship.
Lordship, may kindly pay you.
Yes. Yes. Lordship, the SLC has not maintained the record, Lordship. The record is maintained by the concerned department where from the proposal was submitted, Lordship. And therefore, immediately after receipt of of the order of this honorable court, Lordship, the Chief Secretary of Assam, Lordship, it sent a letter to the concerned department. It is Irrigation Department. This is the communication dated 4 October 2023, Lordship. SLC recruitment. Oh, own report. Back to the report. What are the report?
Then what happened?
In that case, I'm 2 weeks time.
We had given you specific direction, officer has to be present. Who is the officer? Irrigation.
In fact, Lordship, it was the direction was given to the government advocate, Lordship, which is clear in by the order, Lordship.
So they don't have the records.
So, Lordship, I have to wrote the department, Lordship, for records.
Your department has been informed by the chief secretary by this letter, 4th of
Lordship, give
October.
Lordship, give me some chance, I will contact the concerned Lordship officers, Lordship.
What sometime you contact him today at 2 o'clock. Tell us what you're going to do. In view of this letter.
Lordship, I have come to know just now, Lordship.
You have come to know just now, but you tell your officer that whether they have received this letter or not.
That I have to take it.
You find out.
Lord.
You tell us at 2 o'clock.
Lord.
What is the status when they want to produce the records?
Lord.
At 2. Yes. 28, you said something about some other matter being listed. What is the matter here?
This matter relates to payment of pension. The petitioner before Lordship was appointed as
You wanted to say that this matter to be listed along with some other matter.
Lordship will take up this matter, Lordship will take up this matter.
All right. He was never regularized. So therefore, for pension, how many years of service she had put in?
Since 1995, 20 years, 23 years. In the connected case, these are the orders. One order, directed to pay the gratuity, amount of gratuity.
So this is part heard.
It has been released,
Huh?
It has been released, unfortunately, I was out of station on that day,
So why has it been shown? Why?
Initially, it was part heard,
No, that's all right. Now, for what purpose have you placed these orders?
In that case, identical text, identical text.
But what is the final order passed?
Final order has not been passed,
Then?
but by the interim order, gratuity was directed to be paid, in the subsequent order.
Gratuity.
Gratuity.
That we can do. There's no problem on that. But you have already received gratuity?
No, I have not received.
You have not received?
Not received.
You give the gratuity, we'll examine the matter regarding. There were other earlier matters that rendering service as master role.
Casual worker, Lordship. This is not master role.
Huh?
In our affidavit, we have clearly stated.
See, the whole problem that comes up again and again, why do you employ casual workers? Why do you employ? Create post, go for regular employment if you want. You are behaving like a private organization.
Not that lordship. There
And
was
if,
their
if,
lordship.
if these are all unauthorized, you should take action against the officers who have issued unauthorized appointment order.
Appointment was made, my lord, on date of my husband, my lord.
But there
is
was
not-
no letter of appointment annexed to this writ petition.
Where is your letter of engagement or appointment?
There is no such appointment order, my lord.
Page number?
I was verbally engaged, my lord.
Of verbal engagement.
Yes, my lord. I was allowed to continue, my lord, since retired.
Who verbally engaged you?
The director of my lord. Printing.
Why have you not arrayed him as a party by name?
See the party, my lord.
No, by name. Who is the director who engaged you verbally?
Person concerned, yes, lordship.
You give his name?
Director printing is the my lord.
No, no. By name you have to make particular.
How can you do that?
My lord,
And from since when have you been working?
My lord, I was working since 1996, my lord.
96 on verbal orders?
2/3/1996.
Any extensions given thereafter?
I was allowed to continue till the age of superannuation, my lord.
And what payments or emoluments have you received?
Payment, my lord, as per the open dash, they have given the benefit of minimum scale of pay. Initially, I was paid the fixed pay, my lord.
In cash?
No, my lord, in my account, my lord, it was paid.
You give the particulars.
And
You
in
show
their
us the
affidavit,
particulars.
in their affidavit, my lord, they have admitted that I was appointed on date of my husband, my lord, as casual worker. Paragraph 5 of the affidavit, my lord.
Which affidavit?
Affidavit filed by the, my lord, respondent number 2, my lord, page 28. Page 28, my lord, paragraph 5.
What is this engagement on verbal orders? And payment of money? Who is this director who has engaged on verbal orders?
Lordship, there is no mention of this lordship in the petition itself.
It is there in your affidavit. In your affidavit.
Lordship,
Affidavit filed by the director.
Yes, lordship.
Then?
But what we have stated, lordship,
Kindly
that
para 5.
yes, lordship, but para 6 also has to be. Because he was not appointed as a master roll worker. In para 5 it is stated, lordship. And in subsequent paras also we have stated that wages of the casual workers are paid on daily wage basis, lordship. And he was,
That is what I am asking you. Daily wage on what? And cash?
Payment was paid, my lord, monthly wise, my lord.
Fixed pay remuneration of 15,900, lordship.
Who releases this amount?
In para 9 it is already stated, lordship.
No, but how can anybody be engaged on a verbal order? You have been engaged as a casual worker, Mr. Soikia.
My lord.
You are engaged as a casual worker.
Yes, my lord.
So
But
your
my lord,
claim for regularization will have to be examined first.
my lord, my case is that, my lord, as I was appointed on the date of my husband on compassionate ground, my appointment should have been on regular basis.
Where is the basis to say that? On what basis?
Paragraph 5 of the affidavit in opposition.
After expiry, engaged as a daily wage, not as compassionate.
Yes, my lord, but that was the reason for which I was engaged. That is the date of my husband, my lord. That
We
is
don't
the
know.
scheme
It
for
is.
appointment on compassionate ground.
We don't know.
And
It
that
is
why,
not
my lord,
here.
in the other case, my lord, the record was called for. Record for engagement of my of the petitioner, my lord. In the other case, they have called for the decision by which, my lord, the petitioner was engaged.
By as a under compassionate appointment.
My lord, whether it was on compassionate ground, whether or any other ground.
We can call for the record, that is not a problem. But to say that you are entitled to gratuity,
Gratuity, I am entitled, in the similar circumstances, they have paid. And the Honorable Labour Court also recently has held that in respect of casual workers and master workers, they are entitled to gratuity. This is the order, madam.
yes,
Lordship, final.
you have dug up your own grave.
No, my lord, petitioner do not have any prima facie case to sustain. Lordship will kindly appreciate.
What prima facie? Look into your affidavit at para 5 and 9. You have admitted. You have admitted that you are a master role casual workers. I don't see why the department is not proceeding against these officers.
Lordship.
Under what authority you are engaging people like this, and
He was engaged as a daily wage worker.
why? For what work? For what work?
Yes, perhaps, my lord, that the administrative department will have to clarify. Now, on behalf of the finance department, my first submission will be, my lord.
You are the custodian of public finance.
Definitely.
You
but my
can't
lord,
say that there is no explanation for administrative department, therefore we don't know. It is up to him. It is for you to find out.
Lordship will kindly consider, my lord, there is a case, my lord, where they are seeking regularization. Now, regularization, my lord, post Upendas, my lord, regularization is no longer permissible. Number one. Number two, my lord, an order passed by the Labour Court has been put on record. My respectful submission will be, my lord, this honorable court is not bound by the such order of learned court below.
Bound or not bound, is you leave it to us, we will decide.
My lord.
Question is, number one, his statement is, I was appointed on compassionate ground, but as a casual worker. So therefore, the first question is, how was the appointment made? Second is that if it is casual worker, then also some order is necessary.
Yes. And my lord,
Third is, why casual worker?
yes. Now, casual workers are, my lord, engagement of casual workers is no longer permissible after promulgation of that, my lord, AFRBM Act 2005.
When was it brought?
But it came into effect, my lord, from 1st of September 2005.
So the appointment was made from 1996.
Yes.
Prior to AFRBM.
And some allowance have been given on as far as 2017.
Yes, so he doesn't come within the ambit of a government employee. It is only if the petitioner satisfied his honorable court.
Are you telling me that the director is making payments from his own pocket?
They are making their
Then-
own arrangement. Finance is no longer involved
This
here,
is this is not a department.
This is
What is this? Printing and stationery is a department.
Yes, my lord.
Government department.
So the government department, how can they make own arrangements? You'll have to settle the budget and give them financial head.
Exactly. That's the point. So therefore, my lord, if they are taking any money, my lord, from the finance department towards, my lord, disbursal of salaries, my lord, where is any material on record to show, my lord, that they were regularly engaged? Only if a person is regularly engaged, then only, my lord, the question of, my lord, releasing money through, my lord, finance department will come into play, my lord. That is my respectful submission. These are all stopgap arrangements, my lord. Every department now and then makes, my lord, takes up appointment of this nature, my lord. Consider seen, my lord, prima facie, my lord, this is a casual nature of appointment, my lord. Now, I can understand, my lord, that he has been appointed.
Yes, madam, get the records of this particular employee. Let us find out what is, how the department can engage from 96. If it was compassionate appointment, then it could not have been casual worker.
But we have ruled out about the compassionate.
This is exploitation of the highest order. You cannot be permitted to do like this. Let us have the records, Mr. Soike.
In the meantime, in the other case, there is a direction for payment of the
You
gratuity.
renew your, we are not rejecting it. Let us have the satisfaction of going through the records first. Find out. How soon can you get it, madam? 10 days back. Can we have it on 1st of December?
My lord, along with WPC 4232 of 2022.
That you make a mention later on, if required. Because that matter is yet to be listed. So we can't issue a direction that it should be listed like that.
Make this prayer in the other case.
You may make the prayer in the other matter. Let the matter be listed on 1st of December, on which date the learned government advocate MS M. Bhattacharya will produce the relevant records from the available with the respondents. We are saying respondents. We are not identifying which respondent, which will reveal the manner in which the petitioner was engaged as a daily wage mazdoor / casual employee, within brackets skilled worker, as stated under the Directorate of Printing and Stationery, with effect from 2/3/1996. Stop. These records are necessary to verify the claim of the petitioner that the petitioner was engaged as on compassionate appointment pursuant to the expiry of her late husband Hafiz Moinuddin Ahmed. Stop. The further claim of the petitioner is that since the petitioner was appointed as on compassionate ground, her appointment ought to have been as a regular employee, not as a casual or a mazdoor employee. Stop. Petitioner therefore claims that having rendered all the services, she is now entitled to be granted pension and all other retirement benefits. Considering these submissions, the records relating to the appointment of the petitioner is called for, as no document or order has been enclosed to the petition, enclosed with the writ petition to support the contentions of the petitioner, and also further, as it is submitted that petitioner was engaged on verbal orders by the then Director of the Printing and Stationery.
It has been admitted by their in their affidavit. Which has been admitted in their affidavit.
Which is also admitted in the affidavit filed by the department. Stop. Let the records be produced on 1st of December. Mr. R. Pujari appears for the Finance Department.
Obliged.
Yes, 29. Admission hearing. Or we post it for hearing.
Lordship, small matter, like it can be disposed of also if your lordship wants.
Your pleadings do not look
Pleadings are
small.
rather complete. They have already filed their affidavit.
Is National Coal Wage Agreement. Yes.
Matter pertains to compassionate appointment. The petitioner, after the decease of the father of the petitioner has applied for this compassionate appointment after fulfilling the criteria in the prescribed format.
Yes.
But thereafter, like no order was passed as such, and then there was some discrepancy in the age, in the date of year of birth of the petitioner.
Hmm.
So as such, like the petitioner have been submitting representation and then submitted documents and the required documents as sought for by the respondent authorities from time to time. But lastly, his representation was not considered. So the petitioner, it was this process started in the year 2016. So thereafter, the petitioner, being aggrieved, has filed a writ petition before this honorable court. And this honorable court, by order dated 2/2/21, has disposed of with the direction to the authorities to consider the application of the petitioner within the period of 2 months. 2 months elapsed. Nothing was done. As such, the petitioner has filed a contempt case. In the said contempt case, the notice was issued. In the meantime, the petitioner was called before the respondent authorities to appear before the authorities concerned, and the petitioner appeared. Here, the petitioner was asked to withdraw the case, which the petitioner denied. And
Which
for
case? The contempt case?
yes, Your Lordship.
Ah.
He
But
denied
no order was passed.
Thereafter, the impugned order was passed on 10/1/2022.
Page number?
It would be on page number 22.
22.
Yes. In reference to the subject as mentioned above in the order of the Honorable Guwahati High Court, dated 2/2/21, in case number WPC 5678/2019, this is to inform that as per the instruction received from the competent authority of Coal India Limited, Kolkata, on 31/12/2021, your candidature for dependent employment in Coal India Limited against your deceased father is not recommended, not approved for offer of employment on the ground of dispute in regards to your date of birth, as the same could not be ascertained.
Yes. There's some discrepancy with your date of birth.
Yes, Your Lordship.
Then?
The petitioner's case is that like his date of birth is in the year 27 August 1995,
Yes. Then?
whereas it has been wrongly
Entered.
entered
Where?
in the service book of the petitioner's father as 27/8/1993.
No, this is to the whose date of birth?
The petitioner's date of birth.
Petitioner's date of birth.
Yes.
Okay. The date of birth entered in the service book showing him as dependent, family member.
Yes. Service.
That has been wrongly
Yes, Your Lordship.
entered.
And for which this dispute has been going on for quite some years, like during the and before the death of the fathers also, he has already submitted a representation for correction of the date of birth of his son. That is the petitioner.
So what is the basis of your claim now?
Lordship, my claim is that it is wrongly entered.
I know. What are the documents you are submitting
We
in
have
support?
already submitted earlier also, Lordship, along with a copy of birth certificate, HSLC admit card.
All right. This birth certificate at page 25 is yours.
Yes, Your Lordship.
And the date of birth shown in here is the correct date of birth.
Yes, Your Lordship.
And where is the date of birth in the service book?
And initial one of our affidavit. Initial one of our affidavit.
Annexure 1. Is it on the basis of some documents available in the service book? This date of birth?
The statement of the father. Father applied, and surprisingly, Your Lordship, he applied in 94, showing that his son was born in 95, 93.
So apparently it is a wrong date.
93 is not the wrong date. 93,
94, 5194. Date of application is 5194.
94.
Okay. Now he says it is,
Correct date is 93.
no, the petitioner says it's a wrong date.
He was born in 95, according to him. How can the father give a date of a son not born?
Yes. He had some premonition that you're on your way. Perhaps.
Lordship, on that part, I would not say anything because like, I mean, so whatever my father did, I do not know. Like, I mean, but as per my records, all my documents is 95. And on several occasions, I've already submitted my distinct birth certificates as well as with the necessary required documents, whichever the authorities.
No, that's
have
quite all right. But
Yes, Your Honor.
if it is available, you may apply under RTI to get the details of the service records. But the service records details are entered on 8194. So on 8194, your father would not have given a detail to show that you will be born in 95.
I do not know what is the reason behind why he did that also, but like.
You do not know, but you will have to make attempts to now find out. Merely saying that you have a certificate, birth certificate, and you see your birth certificate showing your date of birth of 95 was issued in the year 2007. Now, there is a procedure under these Act and rules that if it is not within 1 year, you have to file some applications. Mr. Soikia? No, we are sailing with her, no problem. But since you were here, we thought.
Well, the issue has now come down to the earlier order. Pursuant to the earlier order, they have invited me to their office. I appeared. They said that I must withdraw the contempt petition that was filed in the meantime. But as I did not agree, they did not issue any appointment order. Rather, it has been rejected. Now, in the affidavit in opposition, what they say, they said that on that particular day when I was invited to their office, they were asking me an affidavit. That affidavit.
No, that's okay. What in the face of these documents available on record, either you have to say that there is some discrepancy apparent on these records, or they are manipulated records, which you.
No, they are not doubting, they are not. It is not a case of manipulation.
Right.
They are only the question that which one is the date of birth.
No. Their records reveal your date of birth as 1993. But the document which you submitted shows your date of birth as 95. Now the date on which these records were entered was 94. Either you say that is it the application of your father.
My father has given a that 93. During his lifetime only he has made an application to correct it. That was not done.
You say where is that? Where is that application?
Page 27. During his lifetime only, and the matter had processed various the communications or the minutes of the meetings. They only said that to verify the actual date of birth. That much. They are not doubting any documents. My school certificate, everything is there. Page 27 of the. The photocopy of the original is the next page, my lord.
Hmm.
It was processed, but then, my lord, in the meantime, he, my lord, expired. Then, my lord, the question of appointment on competition ground had come.
Is there any application filed for correction, for rectification? Petitioners state that
It was, but without any document. That's the reason we could not consider.
no, this particular documented page 27 shows that some documents were enclosed. Page 27 of the writ petition.
I've seen that.
In your records, is anything available?
The affidavit in opposition, paragraph 18. Ultimately, the issue has, my lord, boiled down to this of the affidavit in opposition, page 8, my lord, paragraph 18. Against my statement in that while categorically denying the characteristics of the development made in paragraph 10 of the petition, their humble answering deponent states the petition was called only once in the office of the NEC CIL Margarita. Since the petitioner did not rectify discrepancy with regard to his date of birth, the respondent company on this side has decided to give an opportunity for clearing the dispute, and for that reason called the petitioner in the office and was asked to submit an affidavit declaration with regard to difference in his date of birth as recorded in the service record of the father of the petitioner and the birth certificate and the HSC board certificate, and that he shall be fully responsible for dispute arising out of the documentary proof submitted by him. So this has come down to this. This particular affidavit was already submitted with them much prior to this date, and it is on record.
Page
But
number?
even now, if they
Page number?
Page 8.
Affidavit.
Affidavit, page 8, paragraph 18.
No, that I've seen. Where is the affidavit?
Affidavit in my record.
In your writ petition, available in the pleadings.
Yes. Page 43. Page 44, I am enclosing an affidavit.
40?
It starts from 43, my representation. Then you'll also will find in page 44, the last line, I am enclosing an affidavit in copy relating to my date of birth. And this affidavit, my lord, is at page 46.
There's no 46. There's 45. There's no 46 here.
Of the writ petition.
It ends at 45.
Writ petition.
It ends with your application.
Application and the next to that,
It's not here.
there is no further document after 45.
You can verify.
Something maybe our resignation or closure, maybe.
What is page 41?
41 is an application representation by me
To whom?
to the area manager personnel dated 14/12/18.
Okay. Then 42 is a copy 2,
42 is the continuation.
continuation. Then 43 is your representation.
Representation.
44,
44 is the ending part. There,
44 and 45 is the continuation.
yes.
And then your wakalatnama.
Then affidavit.
That affidavit is not here.
I have.
You have a copy. Why don't you consider that affidavit?
Oh, if required, we'll submit a fresh
We consider, then we requested them.
Why don't you consider it as per your statements made in the affidavit, the averment made in your affidavit in opposition?
At paragraph 18, what my friend has read.
Yes.
Clear. So what is the reason?
The reason is he's not given an affidavit.
Yes, exactly. That in that affidavit you have to say that he shall be fully responsible
yes.
for any disputes arising out of the documentary proof submitted by him.
Yes.
He has not done that.
Oh, you submit an affidavit.
Well, I'll submit according to that.
In the affidavit which you have in your copy,
yes,
which is not available in the court's copy, is this statement not available? Is this statement not available? No.
Maybe in the second copy also.
Second copy. Yes, it is here. You did not make this statement.
This they have said in the affidavit. This is submitted way back in 2019.
Very well, you submit another
I'll
one.
submit another one. That's what about to
That's what we told him, we asked him to submit it, not submit.
You submit it.
Yes. If he does so, we'll consider it.
I heard learned counsel for the parties, this request has been filed by the petitioner. By the aggrieved by the fact that that the respondent authorities have not recommended or approved the candidature of the petitioner for dependent employment in Coal India Limited pursuant to the demise of his father, late so and so. What is the name's father's name? Molloy Sengupta, who was working, who died in harness while working under the Coal India Department. Stop. The rejection of the candidature of the petitioner was due to the the discrepancies found in the date of birth in respect of the petitioner as regards the particulars entered in the service book of his late father, showing the petitioner and his sister as son and daughter respectively. Date of the birth of the petitioner was recorded as 27/08/1993. And according to the department, according to the Coal India, the date of entry in the service book on the basis of the application was shown as 8/1/1994, and the application filed by the late father of the petitioner was shown as 5/1/1994. Stop. Under such circumstances, the subsequent date of entry, date of birth of the petitioner, shown to be 27/08/1995 on the basis of a birth certificate submitted by the petitioner has not been accepted.
And also school certificate.
Stop. The petitioner has also submitted the school certificate reflecting the same date of birth. Stop. Be that as it may, during the pendency of the matter, the response of the Coal India has been filed, and in their affidavit filed at para 18, the petitioner, the respondents have averred that in the event the petitioner files an affidavit stating that he will be fully responsible for any disputes arising out of documentary proof submitted by him, the candidature of the petitioner could have been considered for recommendation. Stop. However, since the petitioner did not file the affidavit as required, his candidature was not accepted. Para. Learned counsel for the petitioner submits that an affidavit was filed as required as far back as when did you file it?
2019.
It was filed on 29/1/2019.
29, 24, 24/1/2019.
Along with the representation dated 29/1.
Along with his representation dated 29/1. Stop. Perusal of the affidavit reveals that the statement which was required to have been incorporated in the affidavit by the respondent are not found in the said affidavit. Stop. Learned counsel for the petitioner submits that this requirement has been brought on record only pursuant to filing of their counter affidavit, whereas the affidavit filed by the petitioner was sworn in on 24/1/2019. Stop. Para, having heard learned counsel for the parties and upon due perusal of the pleadings of the court, this court is of the view that since there is an averment by the Coal India that if an affidavit is filed by the petitioner accepting full responsibility for any dispute that may arise out of documentary proof submitted by him, his case can be recommended for dependent employment, can be considered for recommendation towards dependent employment. Stop. Under such circumstances, and also on the submission of the learned counsel to the petitioner that affidavit as required with affidavit as required accepting full responsibility for any dispute arising out of documentary proofs will be submitted by the petitioner within a period of
10 days.
2 weeks from the date from today, and thereafter the necessary orders. Thereafter his case should be considered by the petition by the respondent authority without any further delay. Stop. In that view of the matter, the writ petition stands disposed of. Petitioner will file the necessary affidavit incorporating the statement as required and as is revealed in the affidavit in opposition filed by the petitioner, filed with the respondent at para 18. And thereupon, within a further period of 2 weeks thereafter, the respondent authority will pass necessary orders on his application for consideration of for being appointed under compassionate appointment. It is made clear that if any further documents are necessary, the same may be inquired, same may be called for from the petitioner, and and the relevant documents necessary be made known to the petitioner prior to passing any orders for consideration. With the above observations, writ petition stands closed and disposed of. No order is proposed.
Any order, they may take a decision.
Any decision taken by the department, a copy thereof shall be furnished to the petitioner.
May pay further, for outer limit, giving 2 months or 1 month.
The entire exercise will be completed within a period of 60 days
2016,
from the date of receipt of a certified copy of the order. We had already indicated
yes,
2 weeks further after you submit the affidavit. Yes. Yes, instructions. Did you get any?
I'm happy for some more time.
Mr. N.K. Devnath, Learned Standing Council, PNRD, prays for further time, further 2 weeks time. Prayer is allowed as it is not objected to by the Learned Council for the petition. List after 2 weeks.
Can it be after 1st December?
List on 4th of December.
Doctor, I'm praying for 3 weeks time to file our affidavit, Lordship. I'm appearing for KAC, Lordship.
Why?
And moreover, Lordship, the affidavit filed by the respondent number 5, that copy we have not received, Lordship.
So you asked respondent 5, who is respondent 5? Why have they not received? Why have they not given you copies? Who's respondent 5?
Lordship, I'm it's the superintendent of police.
Huh?
Okay, my friend.
No.
Superintendent of Police. Serve a copy, madam.
Lordship.
Yes.
No.
Learned Counsel for the respondent prays for and is granted 3 weeks time. You are appearing for the petitioner? He wants time to file affidavit. Prays for and is granted 3 weeks time. Stop. Mr. So-and-so appears for the petitioner. Does not object to the prayer made. List after 3 weeks. Record the name. Yes.
May please. My lord, we are the selected candidate. The petitioner number 1 and 2 were selected against the post of Anganwadi worker.
Yeah.
And petition number 3 was selected against the post of Anganwadi helper. Under the ICDS project, ICDS project Nogao. But all other selected candidates have been appointed, except the petitioner 1, 2, and 3, I 3, all formalities, after completion of all formalities, the select list was prepared and published, and that select list was also approved by the Director of Social Welfare, I see page 19, 19. Approval of select list subject. Approval of select list of Anganwadi workers and Anganwadi helpers. The reference to letter number such and such dated 26/2/2021. Madam, with reference to the subject cited, you are hereby inform that the select list of Anganwadi workers M and Anganwadi helpers submitted fight letter under reference against 15 numbers of Anganwadi workers M and 4 numbers of Anganwadi helper are hereby approved as follows.
No, some affidavit is required to be filed. It has
Yes,
not been
Lordship,
filed.
we have received the updated instruction, Lordship, because these survey has been done falsely, Lordship.
So you file it, bring it on
Yes,
record.
Lordship,
Bring
we
it on
shall.
record.
We shall.
Let them file the affidavit.
No, no, sorry.
Heard learned counsel for the parties. Government counsel, Mr. MS M. Bhattacharya. Praise for is granted. 2 weeks further time. 3 weeks further time.
Lord.
File the affidavit as it is submitted that comments. Oh, you have received comments, instructions.
Instruction that I have also placed before your Lordship. So
In
from
order
this
to file
instruction,
their
I have to.
affidavit. And obtain instructions and file affidavit if so advised. You have to bring it on record.
Yes, Lordship, I agree.
List up to 3 weeks. 3 weeks? 8th of December.
Deeply obliged.
Wait, please.
Yes, yes, yes.
My lord, my senior is on legs in another court. My lord, there was an interim passed in the instant case, 22/9/2022. May it be continued at any other date, maybe fixed.
Matter be listed after, maybe next week. Listed on 1st. Interim order to continue till the next date of listing.
Highly obliged.
Mr. Hendrik appears for the respondent department.
Highly obliged.
Certain developments were there.
Yes, Lordship. In the meantime, in criminal petition number 882 of 2022, Lordship. Lordship, may kindly see the.
Who's for the petitioner? None appears.
I saw the advocate new Dipankar.
You are for the petitioner?
Yes, my lord.
Yes, yes.
My lord, the case of the petitioner is that, my lord, the promotion of the petitioner to the
No,
court-
last order you said some developments were there.
Yes, my lord.
What
And
developments?
that development is there, my lord.
What is that? Read it out. Read it out. Tell us.
My lord, if your lordship peruses the order dated 25/5/2023, the issue involved in this petition is that the petitioner has not been given promotion. His promotion has been kept under field cover due to the filing of a charge sheet in a criminal case, my lord. So regarding that, my lord, there was a issue that, my lord, one charge sheet was filed in the year 2017. Subsequently, that has been sent for reinvestigation, and another charge sheet was filed in the year 2022. And DPC was held on 19/6/2021. So the contention of the petitioner was that at the time of holding of the DPC, there was no charge sheet. So regarding that, my lord, regarding whether there was charge sheet or not at the time of holding of the DPC, my lord, regarding that a clarificatory order was necessitated from the criminal court, my lord. Now, my lord, in the meantime, challenging the entire proceeding of that complaint case as well as the charge sheet, my lord, the petitioners have approached this honorable court, wherein, my lord, this honorable court has been pleased to set aside entire proceeding of the CRC case as well as the two charge sheet, my lord. This is the order, my lord. So apparently, my lord, now there is no bar for the respondents to open the seal cover of the petitioner, my lord. Promotion of the petitioner, my lord.
Yes, Mr. Nayak, what do you say?
My lord, at the operative portion at page 8, point number 13, my lord. In view of the aforesaid discussions, reasons, and decisions, the present criminal petition stands allowed by setting aside the entire proceeding of PRC case number so-and-so, CT PS case number so-and-so under section so-and-so of the IPC read with section 713 of the PC Act 1988, now pending in the Court of Learned, Court of Civil.
All right. You don't have to read it.
Yes. I'm appearing on behalf of the political department. Lordship, my submission is that, Lordship,
My lord, now
Let him submit.
there are two proceedings. Lordship. One is criminal proceeding under the IPC, CRPC, and there is a Lordship, the departmental proceeding. So there cannot be seal cover of a case of a person, Lordship, based on a criminal proceeding, because that is totally a Lordship different proceeding. Now, Lordship, we have to see whether, Lordship, there is a departmental proceeding pending or not on the where the outcome.
You see what instructions we have.
Lordship, there is a letter written from the political department to the Department of PWD there on what was the date of the DPC when the claim of the petitioner for promotion was kept under seal cover, and as to whether on that date any departmental proceeding was pending against the petitioner directly to the concerned government advocate with intimation to this department, Lordship. So we are here to find out whether any departmental proceeding has been pending against him or not. Because this seal cover cannot be an outcome of a criminal proceeding, Lordship. This is a totally different proceeding. It can be a parallel proceeding, but it's a different proceeding. So we have to find out, Lordship, and we'll provide the instructions shortly, Lordship, that whether any departmental proceeding is pending or not, as an outcome of his a seal cover has been done of his case. So we'll provide it, Lordship.
My lord, let the departmental counsel submit it regarding that, because PWD department, they are, my lord.
Yes. Yes.
Lordship,
my lord, I may reply to the contention made by the government advocate that there is a departmental proceeding, but after the DPC, my lord, recently the departmental proceeding has been initiated, but after the DPC was held on 19/6/2021, my lord. So at the time of the DPC, there was no departmental proceeding. And because on last occasion, my learned friend is awarded only because of the search sheet, my lord, he is at the time of DPC, only because of the search sheet in the criminal case, his case was kept under seal cover.
Yes.
Let him submit.
Lordship, going by the judgment passed in the criminal petition, Lordship, as on date, there is no search sheet pending against the petitioner. That is admitted, Lordship. And his case was seal covered on the basis of a search sheet filed in the year 2017. So if it is not there today, Lordship, then there is no bar for the department to open the seal cover. That is one aspect, Lordship. But if if any departmental proceeding is pending, Lordship, and search memo has been issued in that proceeding, Lordship, and if that is prior to that DPC, Lordship,
if it
in
is
that
prior.
case, Lordship, department may give
Your instructions on that. It is submitted by the learned counsel for the petitioner that the criminal proceedings
Lordship
pending before
Lordship.
A competent court against the petitioner was interfered and set aside by judgment dated 9/10/2023 passed in criminal petition 882 of 2022. Stop. As a consequence, as on date, no criminal proceedings are pending against the petition. Stop. Therefore, a claim of the petitioner that his his claim for promotion having been denied, therefore the claim of the petitioner is that his case for promotion be considered by taking out his case from the seal cover, as there is no criminal petition pending, criminal proceedings pending. So, para. Mr. Nayok, learned standing counsel PWD, as well as Mr. Sharma Purwa, learned standing learned common advocate, submits that notwithstanding there being no criminal proceedings, however, instructions are required to find out whether any departmental proceeding otherwise were pending.
Lordship may also dispose of this matter also
by pending at the time when the case of the petitioner was put in seal cover and the DPC was conducted. Considering the cases of persons similarly situated like the petitioner, except the case of the petitioner. para considering the submissions made, the writ petition, this court is of the considered view that the writ petition can be closed with a direction to make the necessary verification by the department. And if it is found that pursuant to the judgment of this court dated 9/10/2023 passed in criminal petition 82/2022 and pursuant to so and so, if any DPC was held, then whether the case of the petitioner was considered, and if so, what orders were passed. Stop. In the event it was not considered, the department will hold a review DPC considering the case of the petitioner, subject to the fact that there was no pending DPC between the date on which the judgment dated 9/10/2023 passed on in criminal petition 882 of 2023 and any such DPC that may have been held considering the cases of the petitioner.
Any departmental proceeding pending prior to the date of DPC 19/6/2021, because DPC was held on 19/6/2021.
19/6.
19/6/2021.
Right. Prior to the between the date prior to the date of DPC held on 19/6/2021. But then the question of whether your case was put in seal cover only on the case of that, we'll verify it.
The department,
No, so far as criminal cases are concerned, no, as on date, no search sheet is pending. That has been set aside. But if in the department,
Was it put in seal cover or not?
it is seal cover
Why?
because of the search sheet, Lordship, in the criminal case.
So on the date it was put on seal cover, whether it was charge sheet was filed or not.
One search sheet was there.
Yeah.
From the judgment itself, Lordship, it is clear.
You verify and pass orders.
Lord.
There is no finding of the court.
Yes.
That no charge sheet was filed. It is left to the department to.
No, that judgment has been passed. Lordship, set aside. Learned court has set aside the
Court
search
has
sheet.
set aside the proceedings.
No,
No,
as
search
well
sheet.
as the search sheet.
As well as the
Correct, the charge sheet.
Yes, my lord.
But on a date when your case was placed under seal cover, was the charge sheet filed or not?
No, what I'm submitting, yeah, it was there. No. Lordship, court has passed the order only in the last month, Lordship. So
Mr. Counsel,
till that
you're not understanding the court.
Lord.
Query of the court. The day, as per Janaki Raman, the day when you put it under seal cover, there must be a charge sheet filed.
Yes, it was filed. It was there.
According to the petitioner, it was not filed.
No, in the judgment, Lordship, it is clear, Lordship. In the judgment, two search sheet has been set aside.
All right.
One was of
You
2007.
verify and pass orders.
Lordship.
Yes.
My lord, a time frame may be given.
The exercise be conducted within a period of 60 days from the date of receipt of a certified copy of its order.
It may be 1 month because it is under seal cover. They have to verify, my lord.
We can give it under 10 days if you want.
No, they 1 month.
4 weeks, Lordship.
4 weeks. my lord.
30 days. All right.
Obliged, Lord.
Deeply obliged, my lord.
May I please, your lordship? I'm in VC, your lordship.
We'll take it up at 2.
2 o'clock. Lordship.
Yes.
Lordship.
Lordship, I have received proper instruction on 1710. Lordship, I'll need 1 week time to file my affidavit. Lordship. Lordship, the education department has also.
Yes.
Can you see the last order below 14/2023? Kindly please them.
So they were required to file. You have received your instructions.
Lordship, yes,
You have
Lordship.
received your instructions.
Yes,
You want to file an affidavit?
Yes, Lordship. I'll.
Let him
1
file
week.
an affidavit. Learned Counsel for the Health and Family Welfare submits that instructions have been received and he'd like to file an affidavit. Mr. R.S. Chauhan, Learned Counsel for the petitioner, does not object to the prayer. It's the matter after 2 weeks. File it after 2 weeks. It's on 1st of December.
Yes, highly obliged, sir. Obliged.
You are appearing for respondent?
I am for the secondary education department.
Mr. U. Sharma for secondary education. Sir, you are also appearing
Yes, for personnel department.
for Sharma Purva for the respondent department.
Obliged.
Yes,
May it please your lordship. Your lordship, we have received the affidavit in opposition from respondent 3, 4, and 5 only on
Ms.
6
So and so learned counsel for the petitioner prays for and is granted 3 weeks.
Lordship, we want to file an affidavit in reply, so yes.
That's what we said. How
Yes,
much
yes.
time you require?
3 weeks will be your lordship.
3 weeks?
Yes, your lordship.
All right, 3 weeks time is granted. Fine. Rejoinder affidavit. Mr. P.P. Dotto appears for APSC.
Lordship.
And Mr. Sharma Purva for states. Who's for PWD? Is it for PWD? Who's appearing for PWD?
PWD.
All right. We had adjourned the matter. You are referring to some matter earlier. We had adjourned it. Somebody made a mention on your behalf.
My lord, actually I was on legs, my lord.
That's okay. We have adjourned it. I think one day or day after or something. It will come.
No, but there is an interim order.
It will be extended.
Much obliged.
Yes.
That's it. In this case, lordship, direction was given to appoint the petitioner and compassionate ground in any gate for post office.
You say it has been complied with. Has it been complied?
Lordship, actually, he was selected, but there is no vacancy position in the department. Therefore, department has
Who's for
communicated
the
other department.
Who's for the petitioner?
That's it.
None appears for the petitioner. MS
Zebra, lordship.
Debora appears for the respondent. List after a week. Mr. J.K. Goswami for the respondent. After 1 week.
Same matter, lordship.
After 1 week.
Lordship.
Another
Same matter.
Similar matter.
similar.
Similar matter.
41.
41 also. lordship.
All right. List together 41.
The amount has been sanctioned already, my lord.
The bail matter will take it up at 2. The PP is not here. APP is. Oh. We'll just take up the AB matter. Yes.
My lord. Lordship, kindly go to the my lord additional affidavit filed by me, my lord. Your lordship, this honorable court has passed an interim order, my lord. And thereafter, my lord, case 133, my lord, of the additional affidavit.
Yes. Yes.
First interim order has been passed, my lord. That petitioner, in the meantime, if the petitioner arrested, he shall be released on interim PRS. Then we appear before the learned court below, my lord. Case 8/8/2020, order 8/8/2023, page 133, my lord. In that order, my lord, I was allowed to go on, my lord, regular bail. I am reading the order, my lord. Since the petition number so and so filed by the petitioner Albor Ali, paying to comply the order 38/2000 passed by the Honorable Guwahati High Court in AB number so and so. The petitioner submitted one copy of the order dated 38/2023
passed by the Honorable Guwahati High Court AB 1933, it appeared that Honorable Guwahati High Court has allowed the petitioner Lalbor Ali to be released on interim PRS bail in connection with this case, furnishing bail bond rupees so one local solvencies like amount, so the petitioner shall appear. Condition has been mentioned by law, 5 conditions. It is further directed that in the event is found to have violated any above condition is found to be involved in the interim bail granted to the petitioner shall be recalled. The Honorable Guwahati High Court has passed further call for the scan copy of the entire case record including up to date status. Tells the petitioner to submit bail bond as per order dated 3/8/2000. Honorable BA is directed to send the scan copies. Then next page, my lord. Later on, bailor has submitted bail bond, affidavit with photocopy, voter ID are seen, and verified and accepted recall. Now, thereafter, my lord, there are, my lord, 4 date, my lord. 15/9/2023, 3/10/2023, 25/10/2023, 4/11/2020. Next day is 16/12/2023. I am appearing regularly before the learned court below. And my lord, one important thing is that, my lord, if your lordship go to the 161 statement, my lord, in 161 statement, my lord, has been recorded 1, my lord, and one and other person, my lord. One informant is 1, my lord, and thereafter, my lord, 2, 3, 4, 5, 6, 7. Not one statement is not there, my lord. So how, my lord, 6, sorry, my lord, 6 to 20, my lord. That statement has been recorded. My name has not been mentioned any of the witnesses in this case.
How many witnesses are there?
There are 20 witnesses, my lord. No one has said, my lord. In charge sheet, content of the charge sheet, nothing has been mentioned against the petitioner, my lord. Only thing is that, my lord, I responded as absconder, and one thing is that he is not found, so he was declared as an absconder. That is the finding of the charge sheet. And if your lordship go to the
Where is the FIR? Where is the FIR?
In FIR, 11 person has been given final report, my lord. FIR first I am coming, my lord. FIR is, my lord, page 17, my lord. My name is mentioned in 10, my lord. 10. Page 17, my lord. There are 37 person, my lord. Out of
There are other orders passed by this bench pertaining to this FIR. Are you aware? There are other orders passed by this bench pertaining to applications arising out of this. Mr. Chaudhary, are you aware?
My lord, earlier my petition was rejected. Subsequently, second team I filed this
But twice rejected, my lord.
Once rejected, my lord.
Have you verified if there are any other orders?
Lord, I want to state here that, my lord. Firstly, the charge has not been framed yet, my lord, in the trial court, my lord. None of the witnesses have been examined yet, my lord. However, my lord, these allegations are very serious, my lord. There are, my lord, as per a PM report, my lord, death caused due to cut injuries over the head. Multiple injuries were on the forehead, my lord. In the inquest report also, my lord, it is there. Moreover, my lord, there are there are eyewitnesses also there. Independent witnesses are also there. 9.
You'll have to assist the court and verify whether we'll also try to find out. There are.
Yes, my lord. That is why I am submitting, my lord. Interesting thing, my lord. Both that, if your lord, 2 charge sheet has been filed. 2 charge sheet, 1 incident, different story, my lord. That cannot be happened, my lord. Said 1 incident. Said,
Both are before the same court.
My lord, same court, my lord.
Before the same court.
My lord.
How 2 charges?
It is not possible, my lord.
2 charge sheet, one was
part, my lord.
1 charge sheet has been filed.
Part charge.
The affair filed by the, my lord, them, and another charge
No,
sheet
is
has
it
been
2
filed.
separate charge sheet or?
Yes, my lord.
Or
Or
part
1
charge sheet?
incident.
Part.
Not separate.
Not separate, my lord.
No, my lord. I said, so your lordship, 1 incident. I said, discuss later because your lordship.
Initial
All right,
part,
we
my
take
lord.
it up on some other date.
Yes, my lord.
Matter be listed again on. 8th of December. And interim order passed earlier will continue.
8 December, my lord.
8th,
Can it be, my lord, 11, my lord?
11 December. Meanwhile, the registry will call for
the informant.
updated scan copy of the case records. Mr. So-and-so appears for the respondent, Mr. H.P. Biswas for the informant. For the informant.
Yes.
8th.
Oh, yeah.
8th of December. There is a meeting, I am informed, so we'll
Yes,
come
madam.
back at 2 o'clock.
Ma'am.
You just write, come back at 2 o'clock.
One year, Lordship.
Hmm?
I beg to mention item number 40 and 41 year. Your Lordship, when the matter was called for, I was in relaxing another court, Your Lordship. My humble request is that, Your Lordship, my appearance may be recorded.
Oh. Whoever has appeared will be recorded. Okay, we'll see. You give your names. Yes.
I live with.
Yes.
Yeah, my lord, the petition of before your lordship is the serial number.
You're filing for vacating.
First, we have filed for impleting one.
Impletement, all right.
Impleting.
Lordship, no copy has been served on us,
Serve
including as
copies.
well as vacating application. There's
You
some
serve
on
copy,
the-
we will issue notice, serve copies, you can file your objections if you want. Implement.
Lordship, letters of copy, the matter may come up on some other day, Your Lordship.
Implement. We are giving you opportunity to object if you want.
Lordship is issuing notice on that.
Yes. You have not served copies.
My lord, I have given to my clerk, but if it is not, my lord, I'll serve during course of the day, my lord. Lordship fix the matter on Friday, my lord.
All right, Friday. Serve copies.
Today itself.
Serve copies. Yes. We are not recording anything.
No, sir.
You serve copies.
No, sir.
List on Friday, as prayed for by counsel to the petition applicant. Yes, who's for the union? Yes, Mr. Gogoi.
Lordship, as per Lordship's direction, I have received the instruction, Lordship,
Hmm.
regarding verification part of the other similarly situated candidate, Lordship. As per the instruction, it shows that, Lordship, the district administration has verified the other candidates and they have said their never is a Lordship.
They're what? What is the finding?
Finding is that, Lordship, they have certified it as a genuine by the district administration.
And they are appointed.
They are continuing in the service, Lordship.
Then
In
you give the same benefit.
Lordship made on the basis of that.
Third, learned counsel for the parties. Third, learned counsel for the parties. An appointment for Central Armed Forces, Central Armed Police Forces, for my NIA and SSF and Riflemen GD Assam Rifles within bracket AR examination 2018. The petitioner belongs to Newar committee, which is categorized as OBC by the state. By the state. OBC by the state.
Yes.
Stop. The petitioner is challenging which order?
Case 70 NXG, my lord, cancellation of offer of appointment after he joined.
The grievance of the petitioner is that his selection, an appointment was rejected by the respondent CRPF
Yes.
on the ground that his caste within bracket OBC is not listed in the central list of the Assam state, by which he has been granted relaxation for recruitment. Stop. The matter was referred to the Director General CRPF New Delhi for clarification, and it has been informed that if his caste is not notified in the central list of Assam state, then they are ineligible to join the force. Stop. Accordingly, his appointment order, which was issued by the petitioner, by the department, by the CRPF, has been recalled. and cancelled. Agree the present petition has been filed. During the course of the hearing, the respective counsels for the respondents were permitted to obtain instructions. Stop. The learned counsel representing the CRPF, Mr. K. Gogoi, CGC, upon a query by the court, has produced before this court irrelevant documents to show that several other candidates who belong to the same category of same category OBC belonging to the Newar community are already serving in pursuant to selection under the CRPF. A list of these candidates have been placed before the court, which was furnished by the CRPF by their communication dated 23rd September. From the said list, it is seen that as many as 4 candidates who belong to the Newar community have been selected and are presently working. Stop. These candidates who were selected are all residents of various districts in the state of Assam.
They are the same district.
Same district.
Or I think 2 different districts. Two districts in the state of Assam, namely Sonitpur and Biswanath Chari. Stop. The present petitioner is a resident of which district?
Sonipur.
Is a resident of
Now Biswanath.
Biswanath.
Now it will be Biswanath.
Biswanath district. Stop. There is no dispute raised by the respondents that the certificate presented by the petitioner certifying that he belongs to the Newar community is not genuine. Stop. The only ground is that the Newar community is not recognized in the central list of the state of Assam. Stop. However, the other candidates who are shown to be appointed are appointed only on the basis of the caste certificate issued by the concerned DC, showing them to be members of the Newar community, recognized as OBC by the government of Assam. If that be so, there is no reason why the petitioner's case ought not to be considered in the same light by the respondent authorities. Stop. Considering the fact that there is no dispute with regard to the genuineness of the certificates produced by the petitioner, the respondent authorities are directed to provide the same treatment to the petitioner as has been granted to the other candidates belonging to the Newar community, as is reflected from the communication dated 23/9/2023. Stop. In that view of the matter, the petition stands allowed with a direction to the respondent authorities to consider the case of the petitioner and reissue the appointment order to the petitioner for being appointed in CRPF as GD, Constable GD, as Constable GD. Stop. His appointment will be considered to be effective from the date the appointment order. Where is your appointment order?
My lord.
The appointment order stood issued.
Yes.
Till the time it was subsequently
13/3/2021.
Page
13/3/2021.
31.
13.
13.
21.
Annexer E. Annexer E. Page 64.
My lord, offer of appointment is page 64.
64.
Page 64.
Annexer E. 13/3/2021.
13 March 2021. Appointment order. With the above observation, writ petition stands allowed, disposed of.
My lord, my kept as a part of the record.
The communication furnished by the learned CGC is retained in the case record.
And the impugned order, I think he will have to go.
We are directing them to recall, give you appointment. Impugned order dated so and so will be recalled by the respondent authorities.
In this case, I received and not able to trace out the record.
Then
They want some more time, Lordship, to trace out the record.
how much time?
They have not said, they say some more time, Lordship, may give 2 weeks time, Lordship. Because, Lordship, the physical files has been transitioned in the e-file mode, Lordship. This is the problem.
Mr. J.K. Goswami, learned government advocate, has furnished a communication which is addressed to the which department? PWD? Irrigation department. For production of necessary records before the court in terms of the earlier order dated 25/09/2023. Copy of the said communication is placed on record. Mr. Upadhyay, learned government advocate, standing counsel irrigation, submits that because of transition of files from physical mode to e-file mode, for the past 1.5 years, many physical files got displaced or mixed up. Accordingly, the relevant records could not be traced out, and the department is seeking further time to trace out the relevant records and place it before the court. In view of the submissions by the respective councils, the respondents are granted further opportunity to obtain the relevant records and place it before the court. These one final opportunity. 4 weeks. We'll grant them 4 weeks time as a final opportunity. Produce the records and place it before the court. List after 4 weeks.
Interim matter may be continued, Lord.
4 weeks.
Interim matter may continue, Lord.
The interim order will continue till the next 15th December.
My pleasure, Lordship. This is the matter relating to the regularization of my services. Lordship,
Yes.
I am continuing service in last 14 years.
Yes.
In this case, already affidavit in exchange. I have already replied. I have filed that affidavit is already exchange. 14 years. In the meantime, as per this honorable court order, pending salary already paid.
Okay. What do you want today?
My lord.
What is your prayer?
My regularization of the service.
Regularization.
Regularization service. Now continuing for 14 years.
We'll take up the matter for hearing on some other date.
Yes,
It is submitted that the pleadings are completed. The issue involved is the prayer for regularization of the petitioner in the as a extra writer.
Extra writer against the permanent vacancy.
Under the office of the sub-registry Jonai in the district of Dhemaji. Your current salary is released.
Release.
It is submitted that the petitioner is presently receiving the current salary. Accordingly, let the matter be listed for admission hearing. On.
There are sufficient proof also.
30.
There are sufficient proof. Sub-registrars already there are so many papers.
Their salary has been released. He's not in work.
14 December, we'll hear it for admission.
14
admission hearing.
Master.
14 December.
May I please your lordship? I mean, VC your lordship.
What is the matter about?
Matter pertains to non-payment of the arrears salary as well as the retirement benefits of the petitioners. Petitioners had been rendering the service and their service period from 2018 to 2020. During this period,
Who's
they
for
had
the
not been-
respondents? Who's for the respondents?
they were supposed to get some instructions, your lordship.
Lordship, I have an instruction, Lordship.
Yes.
In supplementary budget, this has already been submitted before the authority, Lordship. And thereafter, I don't have any updated.
You get updated instructions?
Yes, 3rd August, there is a
Matter be
communication that this has
listed,
already been placed, Lordship.
Again, on,
Lordship, if I may submit, your lordship,
yes.
if the instructions run in my favor, your lordship may very well dispose of the matter, directing the responses to consider my case as and when the budget is available.
You want the court to dispose it off with a direction that your salary be paid as
Yes,
and when
sir.
budget available.
Yes, your lordship.
Yes, Lordship. I have the instruction, Lordship, may peruse.
Heard learned counsel for the parties, this writ petition is filed by the petitioners who were appointed as Bal Sevika and Bal Sahayika in Ratia Daha Aided Center under the Family Welfare Project, Golakganj, under the district Department of Social Welfare, Government of Assam. They were carrying on their duties, and in the year 2020, petitioners retired from service, superannuated from service. However,
The outstanding salaries from 2018 to 2020.
there is a, however, the salaries from 2008 had remained.
2018, your lordship.
2018.
Yes, your lordship.
Had remained pending on the ground that there was no allotment for budget. The outstanding salary of the petitioner stood at 2,11,120, and that of the petitioner number 2 is 2,15,250. Stop. For the relevant period, stop. The representations by the petitioners fell on deaf ears, and no orders were passed thereon by the respondent department. Stop. Being aggrieved, the present petition is filed. Para MS M. Bhattacharya, learned government advocate, on instruction submits that the proposals for area salary for both the petitioners have been submitted before the appropriate department in the government.
Because the funds were not available on the earlier financial year slot. So supplementary, this has been submitted, and this was on July, Lord.
The supplementary budget has been submitted before the competent authority.
Not only in case of the petitioners, there are others also.
This budget is for payment of area salary for persons like the petitioners, including other similarly situated persons. It is submitted by the learned government advocate that once the budget is approved, and the amount is received, the salaries can be paid to the petitioner. Stop. Copy of this instruction is placed before the court, which is kept in the case record. Para. Mr. So-and-so, learned counsel for the petitioner, submits that the writ petition can be disposed of with a direction to the respondents to release the payments as and when the budget is sanctioned and the amounts are received. Stop. In view of the submissions made and also in view of the instructions placed before the court, considering the prayers made in the writ petition relate only for a direction for release of area salaries, the writ petition stands disposed of with a direction that the area salaries of the petitioners would be released by the competent department as and when the budget is approved and amount sanctioned is received. Stop.
As well as the retirement benefits as well, because they retired in 2020.
This area salary, but it is only for area salary,
Yes, Lordship, only the
not
area
for retirement
salary,
benefits.
I made a prayer, Your Lordship.
You made a prayer, but it is not there. It is your submission that writ petition can be disposed of. If there are any further claims made by the petitioner, including area, including pensionary benefits, if there are any claims of the petitioner, the same may be addressed to the competent authority separately. In terms of the above, writ petition stands disposed of, closed. No order is to cost.
Obliged, Your Lordship. Deeply
Deeply
obliged.
Earlier, 2 occasions, my lord, after the case study was called from.
Not received. Why? Produce it, or you take up the matter with your SP. Why the updated CD has not been received? Short date. When can you do it?
From Tinchukia, my lord.
Huh?
From Tinchukia.
1st of December? 1st of December? As per earlier directions, this case diary, up-to-date case diary as called for has not been received. The learned APP is requested to produce the same, call for the same and produce it before the court on the next date fixed, failing which.
Early, my lord. Yes, 1st of December, too late. Today is
By
8th.
the next date fixed, subject, failing which specific orders may be passed for appearance of the IO along with the CD. Stop MSP Bora appears for the petitioner. List again on 29th November. 29 November.
Obliged.
Yes.
This petition may be closed, Lordship, complied with.
It is submitted by the learned counsels at the bar that the directions contained in the order dated
31/2015.
where is the order?
Page 7.
3001/2015 passed in WPC 3494 of 2014 has been complied with. Stop. A copy of the instructions to that effect, a copy of the communication to that effect has been placed by the respondent counsel, which is kept on record. Accordingly, the contempt petition stands closed as the court does not want to proceed further in the contempt matter in view of the order having been complied with. Contempt petition accordingly stands closed.
Highly obliged.
Notices are recalled. Yes.
What is the matter of compassionate appointment? The order is dated 15/12/2015.
Yes, Mr. Pegu, what has happened?
Lordship, it was placed in the DLC that was held on 26/10/2023, Your Lordship. I've forwarded to Your Lordship.
Where is the order?
At page number 4.
Where is the order?
Order is page number 7, annexure 1.
Page number 7.
Yes, Lord.
What is the direction?
The direction, Lordship, page number 9. May I read this? Okay. That being the position, court is of the view that the case of the petitioner for compassionate appointment is required to be reconsidered by the DLC Lakhimpur having regard to the criteria parameters laid down by the court in the Asuranjan Das more so when vacancies were available. Accordingly, Deputy Commissioner Lakhimpur is directed to once again place the case of the petitioner before the DLC Lakhimpur for consideration in its next meeting. And now it is held on 23. Order was passed on 15/12/2015.
DLC2 very 10/2020.
Where is the name of the petitioner?
Lordship, at page number 4.
Page 4, serial number?
Page, serial number 1, top.
1.
Top.
Have you seen this?
No.
You should show her a copy. You show her a copy.
Yes. Yes.
List on 15th November. You go through the instructions, take it up. Or we can have it on Friday also if you can go through.
Yeah.
Friday?
Friday.
All right, Friday. List on 10th. List on 10th again. Yes.
The records were directed to be produced in this matter. This is a suo motu contempt case taken up by this honorable court. By the last order, it was
Similar instruction I have received, the old record, Lordship, could not trace out, Lordship. Some time required.
What is the point of upgrading to digital mode if you cannot trace out the records?
exactly.
I have already.
So either you have destroyed your records without upgrading, or you have upgraded in a manner that you now cannot find out.
Lordship, I tried to.
Which department?
The irrigation law.
So it's an engineering department.
Lordship.
Now, if the engineers cannot go for proper preservation of the records, just imagine the woes of common citizens in other departments.
And it is of 2015. It's not that 2001 or 2.
No, we give you 2 weeks time further.
Lordship.
Mr. N. Upadhyay, learned standing counsel, learned counsel appearing for the respondent, praise for it is granted. 2 weeks further time to obtain the required instructions as directed. You are appearing for?
Contempt.
You are for the contempt. You are for the department.
Lordship, I am for the department.
For the department, PHE department,
Irrigation
department, which was supposed to produce the relevant records praise for. It's 2 weeks further time as the records, as per instructions received, were stated to have not, are stated to have not been made available, are not traced out in the department in view of the fact that old records might have been misplaced during the process of digitization. Mr. R.D. Counsel appears for the sole respondent.
Yes, my lord.
Sole respondent. In case you don't find records, then we'll have to increase the list of respondents. Mr. H.K. Das appears for the High Court.
Yes.
Registry.
High Court.
All right.
After 2.
Wait, my lord.
Yes.
My lord, by this application, my lord, the order of 3/10/2019 is thought to be, my lord, reviewed.
Page number?
Page number 55.
Yeah. 55.
Yes, my lord.
Why is it necessary to be?
Necessary page 57, my lord, relevant portion, last paragraph, my lord.
Yes.
Accordingly, this petition is disposed of with a direction to the respondent to calculate the pensionary benefit of the petitioner and release the same within a period of 3 months from the date of receipt of the certified copy of this order. This is important. This is further clarified that pensionary benefit will be granted from the date of order dated 4/12/2018, as has been done in similar case. The petitioner in this case, my lord, has superannuated from his service on 39/2015. But the order directed to grant the pensioner benefit from 4/10/2018 on the basis on that day, my lord. The judgment of Sanjita Roy was passed by this honorable court, my lord, declaring that the deduction of 6 years is illegal. One similar person approached the, my lord, before the division bench, my lord. Your lord will find the order, page 59 onwards. And your lord will find a relevant portion.
Who's for the respondents?
I'm for the accountant.
Yes. What do you say?
Lordship, in this case, Lordship, he is seeking the review, Lordship, of order dated 3/10/2019 on the basis of the order passed in writ appeal, my lord. That was passed in the year 2021, my lord.
Hmm.
So
This is in a similar matter.
My lord.
What was the direction of the division
Page
bench?
71, my lord, paragraph 9 in the order passed by the division bench.
So why don't you go in appeal?
Yes, my lord.
But since the matter has already been settled by the division bench, that's why, my lord, review has been.
No, matter has been settled after the delivery
Yes,
of judgment.
yes, my lord.
So where is the error?
Error is not there, but
Then-
since the matter is, my lord, decided by division
No,
bench.
if error is not there, how can we exercise review jurisdiction?
Yes,
Review is for
not
correction of
applicable.
errors. You are within your rights to go and file an appeal explaining the delay aspect or whatever is required.
The court can also
Unless
exercise the power of review,
unless you show that there is some error apparent on the face
my lord. Obviously, my lord, there is error apparent on the face.
after the delivery of judgment. That means the law has been, there's a change in the law. What was held by the division bench?
Paragraph 9, my lord, page 71. An order of the court is always retrospective in nature, unless it is specifically made prospective in the order itself. It is because of the courts do not legislate, they only interpret an existing law. This is unlike the laws made by the state legislature or the parliament, which are always prospective in nature, unless again the law itself makes it retrospective. The original judgment dated, this is the impugned order, 4/12/2018 passed by the so-and-so order does not give benefit to the petitioners from prospective date. Therefore, in our considered opinion, the order dated 4/12/2018 was retrospective in nature, and it would include all similarly situated masteral workers, irrespective of their dates of retirement, provided they are covered by the benefits given to them earlier and were already availing pension.
Where is the judgment of Sanjita Roy?
Sanjita Roy's judgment,
my lord.
Huh?
I have not annexed in this petition.
You have not annexed.
Not annexed. It
That
was
is the
my lord passed on my 4/12/2018 in
You'll have
WPG
to
number
see
1098.
the interpretation of the court is with regard to that particular judgment.
My lord. We are also, my lord, similar to that.
Where is that judgment?
Then I have to produce.
You have to produce.
My lord. I'll
Kindly
produce.
read para 8.
My lord.
Kindly read para 8.
Of my division bench order.
Yes, page 71.
My lord. In considered view, putting a condition that the benefit of the order passed by the learned single judge in WPC 1089/2015 would be effective only from 4/12/2018 is not correct, particularly when there is no such embargo in the order dated 4/12/2018 passed by the learned single judge in so, which held the deduction of 6 years of service was wrong.
Okay. I am told it is available.
Yes.
The writ petition. Strictly speaking, there is no error. It's a wrong interpretation of the order, but that's not an error. Yes,
Well,
Mr.
in fact,
Talukar?
I have annexed my dead order. Well, consider order is there, well, as an extra 6 months.
Page number.
Page number, my lord.
33.
33. Relevant order, you'll also be on page 30.
42. 42.
There are 30 of the judgment, my lord, page 54, 31. Page 55. In view of such position, it is held the deduction of 6 years from their service.
Okay, we'll take it up on Tuesday.
My lord.
14. Please take it on Tuesday.
Obliged.
May I please, Your Lord?
Yes.
The case of completion appointment and their lordship upgradation of this petitioner. Initially, lordship she was appointed in a casual purpose. Subsequently, lordship she has representation to.
I have not been able to understand what you are submitting.
The case of completion appointment also. And initially, lordship this petitioner was lordship appointed as a casual worker on completion ground, which is not permissible, lordship. Accordingly, lordship the board of this company lordship department has approved the case of the petitioner to regularize his service. Accordingly, lordship for approval was sought for from the department. The department has rejected her prayer. That is a page 40.
Yes.
Lordship, here I am appearing on behalf of Mr. Affidavit for respondent number 3. Lordship, we have received the instruction. Kindly 2 weeks time may be granted. We will file our
instruction is in hand.
2 weeks. They've asked for 2 weeks.
Fixing it there.
MS so Learned Counsel appearing for the respondent. Urban Water.
Yes, Lord.
Assam Urban Water Supply and Sewerage Board. submits that instructions have been received and she prays for 2 weeks further time to file the affidavit. Counsel for the petitioner submits that the affidavit may be directed to be filed positively within 2 weeks. List again on 8th of December, by which time the affidavit, as prayed for,
49 is similar.
may be filed by the respondents, if so advised. Yes?
49 is same.
49 similar order. 50?
Much of Lordship. They have filed their response. I want to Lordship file. Reply.
Mr. J. Kolita, learned counsel for the petitioner, submits that weeks time be granted to him, 2 weeks time be granted to him to file rejoinder affidavit to the affidavit in opposition filed by the respondents. MS so-and-so appeals for the respondent. Sewerage Disposal Board.
All right. May please your lord. This is contempt case, my lord. Order page number 11. This is the contempt case, my lord. Order page number 11, my lord.
Page 11.
Page 11, my lord. Relevant court on page number 14.
14.
Last paragraph, page number 14. There is an interim order. Thereafter, my lord, page number 16, I have submitted it, my lord, to the respondent.
Sorry?
Thereafter, my lord, I have submitted it to the respondents, my lord, page number 16.
Then?
Page number 16, my lord. And
what was the specific direction here?
Direction, my lord, page number 14, relevant for my lord.
This matter is still pending.
Pending, my lord. There is an interim order, my lord. That interim order has been violated by the respondent.
Why?
Kindly see.
How do you say it is violated?
Page number, my lord. Kindly see page number, my lord, 27, my lord. They have been issued admit cards.
We'll take it up. Is the writ petition listed?
Not, my lord.
Then we'll let it be listed along with the writ petition. This contempt petition arises out of an alleging willful disobedience of the order dated 1/9/2023 passed in WPC 5046 of 2023. This contempt petition has been filed by the said order. The following directions were issued, page 14, last paragraph. Extract. So, the said writ petition is still pending disposal before this court. Under such circumstances, this court is of the view that the contempt petition be listed along with WPC 5046 of 2023. List accordingly. Next week or
notice? Not.
No, let the matter be listed along with the writ petition. 17th.
Obliged.
In this matter, my lord, I have entered into evidence for respondent number 4, 5, and 6 today. I have filed the wakalatnama, my lord. Some time will be required for filing the reply.
It is that voluminous affidavit file. That matter.
No, my lord. In the writ petition itself runs into 263 pages, my lord. Readings only, my lord.
Pleadings.
Pleadings.
Okay.
I also pay for some time to file my reply, my lord.
They have already got 8 months time, and most of the document they have already gone through. Most of the document they have issued by them also. They already gone through most of the document during the discipline. They have their department, they have their legal cell.
No, but they have to file, they are entitled to be given an opportunity to file their response to the petition that you have filed. Your petition will comprise of the body of the petition as well as the enclosures or the annexures.
But for that already 8 months time they have already got, and there is no wakalatnama filed by from.
He says he's filing it today.
I have already filed it, my lord. 4, 5 and 6.
Even for 2 and 3 also.
2 and 3, I think you're the retainer counsel. You have to file your memo.
But the last hearing, I was allowed to file my prayers in written form. Can I submit it?
Yes, you can. Let the matter be.
Lordship, during the discipline process, I did not receive any CTA rule, copy of the CTA rule. Though they mentioned that there is an amendment, but they did not mention specifically. So
We'll see, we'll hear about that.
If I get the CTA rule within a period of 3
What do you want?
Company CTA rule.
What is that?
The conduct, discipline and appeal rule.
So you furnish him?
Along
When?
with the amendment copy, Lordship. I need a certified copy because there I have faced lot of manipulation. Therefore, I need a certified.
Is it not available in your website?
That I have to check, madam.
Put it up in your website. Let it be downloaded by the petitioner.
I'll provide him a copy, madam. Furnishes his email address, madam. I'll provide him a copy.
You furnish the email, your email. They will give you a soft copy.
I have already submitted in the prayers that I need a certified copy as well as there is a proof of circulation because I have faced lot of manipulation.
You will be given a copy of the CDLO by the competent officer through the email. So the competent officer is expected to give you a CDLO which is accepted to be by the department to be the proper CDLO.
Along the CTA rule is generally circulated among the officer as well as uploaded in system.
We'll mention that. We'll mention that.
Thank you.
The respondent counsels, so and so, are permitted further time to file their respective affidavits. Stop. The prayer of the petitioner in person is that he has not been furnished with a copy of the, what is that company?
The conduct, discipline and appeal rules.
Conduct, discipline and appeal rules followed by of the Numaligarh
refinery.
of the Numaligarh refinery. Stop.
In last hearing, there is a order that details of pending dues as well as salaries as well as medical benefits were supposed to submit today. And accordingly, if any dues were pending, like accordingly, in the order it was mentioned that accordingly it should be done.
Do you have your email here? Is your email available?
In the petition copy, my
Hmm?
in the petition copy, in the repetition.
What is your email?
op_ac@yahoo.com.
Okay. Mr. Deka, you'll find the email in the application before the Chief Justice. It is there in the record. Kindly find out. We are flag marking it for your. We are flag marking it for your convenience. All right. The respondent Numaligarh refinery will furnish authenticated copy along with its amendment of the conduct, discipline and appeal rules followed by Numaligarh refinery. will furnish a soft copy of the so-and-so to the petitioner at his email, which is reflected in the case records as under. We are recording this. This is your email. Stop. The said CDLO be furnished to the petitioner within a period of 2 weeks. 2 weeks from today.
Authenticated means we'll have to certify on each page.
No. Authenticated means the copy which is authenticated. He's saying that some circulation, some amendments and everything is there. So authenticated means, if possible, you authenticate through digital signature, whatever is there by the competent officer. Matter be listed after 4 weeks, enabling the respondents to furnish their affidavits. You will need some time to go through the CDLO once you receive it.
I don't require any time.
You don't, but you have to get a copy.
Yes, yeah, I need a certified copy because I have faced lots of manipulation.
We have directed the authenticated copy.
Yes.
So, all right, list after 2 weeks on 28th of November.
I have filed my wakalat number today only, my lord. I'll be in need of some time, my lord. 4 weeks lordship will give me within this period.
He's asking for some interim reliefs. If you're agreeable to paying him some benefits, then we can grant you.
As per my instructions, my lord, there is nothing.
Exactly what he's claiming.
Let him claim, my lord, because his claim is for some benefit. He's a removed employee. As per my instruction, everything has been paid, my lord.
Lordship, for last 1 year, from before imposing
Therefore, we want you to file your response.
My lord, we'll file it.
Unless you file your response, how will the court decide whether the claims are correct or incorrect?
Fine, my lord. Then my lord will kindly give me 3 weeks time, not 4 weeks. 3 weeks time.
Already 8 months time they have already received.
All right, 6th of December. 6th of December.
Lord.
We are directing you to file it on 6th of December.
Before that, I'll file it, my lord.
You file it and you serve copies by digital mode if possible. The emails are already there.
Yes, my lord. Yes.
So before 6th of December, can I get the reply to the petition?
Sorry?
Reply of the petition. Can I get it before 6th of December?
Yes.
Reply of the respondents. The company.
Petition against the reply from against the each point of the petition. Affidavit in reply
By the
respondent.
That is what they will serve.
Before 6th of
Hopefully. Let us see. It is submitted by the respective respondent councils that they will file their response before the next date fixed.
My lord.
And
is there any fixed date that I can get to receive the company's conduct discipline and attitude?
no. We have asked them to give it to you. We asked you, you said you don't require time to go through it. They will furnish it. When can you furnish it?
Within a week, my lord.
It is further submitted by the by the respondent council for Numoligor that within 1 week's time you will furnish the soft copy of the.
My lordship has already said 2 weeks. Lordship will modify it as 1 week.
1 week.
The order, lordship
1
said
week.
2 weeks.
1 week.
1 week.
Agota said. Modify it to 1 week. You'll get it within 1 week. Petitioner has also submitted his gist of the arguments, which is taken on record. You have to give the other side copy. Whatever you file in court, you are required to give copies to the respondents. All right?
I am requiring for the respondent.
Your name?
A
A. Hussain appears for respondent number 1. List accordingly.
TPO.
Yeah, please, Lord. But in this petition, we are praying for a direction to be issued to the Deputy Commissioner Tinsukia, who is acting as a certificate officer for early disposal of our case. We have a minimum period.
Service on respondent number 3 is completed as per the office note. However, none appears. Accordingly, list the matter for admission.
Lordship, but I need some updated instruction, Lordship. The instruction that was received, Lordship.
List on 1st of December,
Lordship.
by which time the respondents will complete their instructions.
Lordship.
Lordship, date may be fixed.
1st of December.
1st of December. Deeply obliged.
Made clear. Lordship, this is an eye for correction of the mistake, Lordship, in the judgment and order dated 14/6/2023. The name of the father of the petitioner, Lordship, it is given as Kamakhya Prasad Nath. It should be K-A-M-A-K-S-H-Y, Kamakhya.
It should go before the appropriate bench, I think. Matter be listed before the appropriate bench.
Obliged.
Before appropriate bench. Registry to place the matter before appropriate bench.
Obliged.